Star Hydro Power Limited against the National Transmission and Dispatch Company Limited.
Yes, Mr. Landau. May it please the Court, I'm Toby Landau. I appear for the appellant, NTDC, in this case, along with my learned friend, Mr. Tariq Baloch, KC, and Ms. Catherine Drummond. The respondent, SHPL Star Hydro, is represented by my learned friends Mike McClure, KC, Sarah Parrock, and Joel Halliday.
Yes.
My lords, my lady, can I begin by setting out my intended course? All being well, this is the way I would like to proceed. Firstly, to provide you with an overall overview, big picture, as to why we say the Court of Appeal got it wrong and why we say Star Hydro's proposed approach is wrong.
Yes.
Thereafter, I will proceed to what are identified as issues 1A and 1B in the Statement of Facts and Issues, and that is the test to be applied. And that will require me to go into some detail about the architecture of the New York Convention and its relationship with the courts of the seat.
Yes.
Thereafter, I will then move on to the Lahore application and what is actually happening in Pakistan. After that, I will then move on to what are identified as issues 2A to E and 3 in the Statement of Facts and Issues. And this is on the assumption that the court is not with me, and the court considers that it can consider what we've called merits issues. I'll then address you on what the merits issues are, whether common ground can be part of an award, whether partial recognition and enforcement is possible, whether perceived motivation is relevant, and the question of preemptive applications. And then lastly, I will come to what is at the end of our case, which is if you consider that the arbitration agreement has been breached, whether or not there are strong reasons not to issue an anti-suit.
Yes.
My lords, my lady, in terms of the overview, the first part of this, the Court of Appeal anti-suit injunction order is unprecedented. It is an order stopping New York proceedings abroad. That has never happened before. And it's not happened in England. To our knowledge, it's not happened anywhere around the world. No case has been cited where a New York Convention application has been restrained by an injunction coming from the seat. The injunction is premised exclusively...
What about the decision of His Honour Judge Pelling that is referred to?
Yes, so I'm going to come to that in my overview, because the Court of Appeal was unprecedented, and it's led to Judge Pelling's judgment. So we may now see a flood following the Court of Appeal, but the Court of Appeal was the first time it happened.
Right.
And I'm going to take you to Pelling, because the Pelling judgment, if I call it that, because that shows, in my respectful submission, the danger that we're now in with this new test. Just to be clear, the anti-suit injunction was issued on the basis of an alleged breach of the arbitration agreement only, not vexation and oppression, as being the other possible head. The fundamental error, this is now in my overview, the fundamental error in my respectful submission that the Court of Appeal made and that Star Hydro now make is to extend the well-accepted principle in C versus D to New York Convention. That's the short point. C versus D is a well-established line of authority which allows the English court, as the court of the seat, to restrain any attempt to seek abroad relief that should have been sought in England, like setting aside of the award. What has happened is that principle has now been extended into something totally different, which is the field of recognition and enforcement of awards, New York Convention. And in so doing, as I'm going to show you, the Court of Appeal has gone further, which is now very clear from Judge Pelling's judgment, of actually imposing English law as the law to interpret a multilateral convention for other states. So those are two related points. So what it's saying is that, as far as England is concerned, when it looks and it understands a New York Convention proceeding abroad in another New York Convention contracting state, you do that through the prism of English law, and you only allow what English law would allow in England. Can I now do something which I do with some trepidation as counsel, and that is to paint a big picture of the whole case, knowing that the court will have lots of questions and I might not get to my detailed submissions in order. But the big picture is very important. And having painted the big picture, I then need to flesh out each part of it in stages. So the big picture is this. The New York Convention of 1958 established two distinct types of control over international arbitration. If I can paint a graphic, if you imagine a piece of paper with a line down the middle, the New York Convention established two sides. One side is control by the courts of the seat of arbitration. The other side of the line is control by the country where anybody is seeking recognition and enforcement of an award. So in an arbitration, there will be one seat on one side of the line, and that's the supervisory court. On the other side of the line, as it stands at the moment, there will be 171 possible jurisdictions around the world, because there are 172 contracting states to the New York Convention. So the system that the New York Convention brought into play was that you have control, two types of control. Control and supervision at the seat. That leads up to the rendering of an award and remedies at the seat on the award. The award creditor or the award debtor can take, we'll come to that point later, that award can then be taken to 171 other jurisdictions around the world for recognition and enforcement under the New York Convention. And in that process, the court that's being asked to recognize and enforce also has control. So that's called double control, which we'll see throughout the Travaux, throughout the law and commentary on this area. On each side of that line, there are carefully calibrated provisions as to what each court can do, and they have to sit together. So on the side of the seat court, if it's England, it will be Part 1 of the 1996 Arbitration Act, and I'll take you to those provisions in detail when I get to the detailed submissions. But just to paint the picture, you'll have Section 67, 68, 69, setting aside for jurisdiction issues, procedural irregularity, and in some cases appeal on law. That is then matched by, on the other side of the line, Article 5 of the New York Convention, which lists almost identical grounds. And those are grounds upon which a party can be deployed to resist recognition and enforcement in a particular jurisdiction only. So the grounds are the same, for example, lack of jurisdiction, improper constitution of the tribunal, breach of natural justice, etc. But the exercise on each side of the line is fundamentally different analytically.
And can I just check? Regulation or control by the courts of the seat, does that have a sort of erga omnes effect against all other states? So if the courts of the seat set aside an award, which I think they can do, does that mean the award is no longer valid and can't be enforced? Correct.
That, my Lord, if I may say, is the critical point. Each kind of control is different.
Well, is that proposition indubitably true? I mean, if the award is set aside, then that itself creates a ground for non-enforcement or recognition, doesn't it, under Article 5.1e, I think?
Correct.
It might also, I suppose, create an issue estoppel, which would be a separate basis, which would depend on the law of the state. But apart from that, it doesn't have any sort of inherent erga omnes effect, does it? Those are the two ways in which it might.
So, my Lord,
and even Article 5, 1, it says recognition enforcement may be refused, and there is some law, I think, saying that it may not be. They may decide not to refuse.
My Lord, if I can take those two together, there are some exceptional cases where an award might be set aside at the seat but still enforced.
Yeah.
And we have an example in this country of UKOS, where it was set aside award was set aside by a Russian court, and it was felt that that was corrupt and couldn't be relied upon, wouldn't be recognized in this country, and therefore that set aside wasn't given weight. But just talking about and I'll come to all these examples, but the architecture of the New York Convention is, if I may say, precisely as my Lord Sales has said. The remedy, the control at the courts of the seat, is erga omnes, in the sense that it is a remedy directed at the instrument of the award itself for all purposes. And that means you've rendered an award at the seat can set it aside, the seat can remit it back to the tribunal, the seat can amend it or vary it, and that changes the document, the award itself, for all purposes. So that when, in terms of the structure of the New York Convention, when you take that award around to 171 countries, you'll have to reckon with the fact that it's been set aside at the seat.
Provided they recognise
Yes.
what's been done at the seat.
But, my lord, that's right, except that this structure, now, again, I'm going to take you to all the authorities on this, the fundamental architecture, this is how double control was put together. The fundamental architecture is premised upon this difference. There will be exceptional cases, and they're exceptional, each one with its own reason, like UKOS, a corrupt court. And there is also a line of authority coming from France where they take a slightly different view about a transnational validity of an award separate from the seat, which is not recognized in this country. But in terms of the architecture, it's erga omnes on one side of that page, but in contrast, if you go to one of the 171 other countries and try and resist recognition and enforcement, it's not an erga omnes remedy. What you're doing is you're simply saying that award should not be given any effect in that jurisdiction. And then the structure of the New York Convention is such that you can then do the same thing in 171 other countries. Each country, under the New York Convention, when it's receiving an award, is simply answering the question, what effect, if any, do we give to this award in this jurisdiction? That's it. And that's how the drafters of the New York Convention managed to construct double control. Otherwise, you would have a complete mess. That's how logically they sit together.
Yeah.
And I'm going to take you through, I don't want to make this sound inter orem, but there's a lot of authority explaining this difference, just how these two sit together.
But I mean, if I may say so, you've explained it very clearly. I mean, do we need to wade through lots and lots of authority other than be aware that it's there and you say it supports what you're saying?
Is there no potential issue estoppel created by the judgment of one enforcing court in another enforcing court, or does that depend on the second enforcing court?
Yeah.
Exactly.
Yeah.
My lady, it's a controversial issue. At the moment, there's nothing in the New York Convention on issue estoppel.
It's a point that's been argued from time to time.
From time to time.
I think different results may have been reached.
Very different results. Some countries don't have a concept of issue estoppel. Obviously, civil law countries won't apply it in the same way. Some countries, for example, the Court of Appeal in Singapore, have accepted that you might get an issue estoppel possibly from a decision of the seat court on a recognition and enforcement court. But they've said, the majority in the leading case in Singapore says not an issue estoppel from one recognizing and enforcing court on another recognizing and enforcing court. There's clear material in the travaux of the New York Convention against any issue estoppel because it breaks down the whole structure.
Yes, I was going to say, I mean, the Singaporean approach seems a bit strange, given that the architecture is as you've said.
You can't have this architecture if you then have issue estoppel. And when one looks at the concerns of the contracting states when the New York Convention was drafted, the concern was that double control was essential. The seat is not given primacy. And every state, if it's going to be asked to apply its powers of compulsion to an award, has got to have the right itself to consider whether it wants to recognize and enforce the award. And that's why, when you look at that, there's no room for issue estoppel. So issue estoppel is not in the Convention. It's not about, it's some domestic law, as my Lord has pointed out. There's a debate.
But where then does the obligation of an enforcing court to recognize an amendment or a variation of the award by the seat, where does that derive from?
Because that is the power of the seat to actually, as a supervising court, to rule upon an award within its jurisdiction.
Yes.
And that's reflected in Article 5 of the New York Convention, Article 5(1)(e), which says that one ground for non-recognition and non-enforcement would be a setting aside at the seat.
But even that, you say, it's not, or do you accept that the Convention doesn't make that mandatory?
Correct. Correct. And so that again feeds into this critically important point that you've got to maintain double control, that each recognising and enforcing court's got to have its say. And it does so by its application.
I mean, that's because you're invoking the sovereign power of
Correct.
Of that jurisdiction to make the award stick.
Can I just add one further?
Why isn't it mandatory? I mean, the logic of the way you've set it up would seem to imply that if you've got decisions of the seat that is ultimately deciding, let's say, the arbitration award is invalid, then logically it shouldn't impact, should it, on the enforcing state?
Meaning the enforcing court shouldn't have a discretion?
Yeah.
No, because UKOS is a good example. You will have cases where something perverse has happened.
Yeah.
A local court might be corrupt and has set it aside in manifest...
The general prima facie position is that that if it's void in the seat, as subsequently decided, or some problem, then that isn't going to be recognised and enforced.
Correct.
On the other side of the line, so to speak.
And this is
but you do get occasional
cases.
Yeah.
And that's why they couldn't say shall, they say may, again, because they want to preserve the authority of that control on that side of the line. And just for your note, I will come to it, there's a decision called Astro, PT First Media and Astro in Singapore, which makes this point in terms, saying because of the erga omnes effect of an award, it's very difficult to see where an award that's been set aside could be recognised and enforced, absent some exceptional circumstance. So...
what's the reference for that?
I'll have to... just quickly come to that. Can you find it for me?
Well, if you're going to come to
I'll come to it.
Let's not take up time. No.
So, where that leads us, and again, this is, believe it or not, still my overview, where that gets us to is what is the approach of this court in terms of...
Just on
Yes.
Lord Burrow's question, I mean, presumably, issues of comity and so on come into play with the recognition courts, so that if they can see that the courts of the seat have set aside an award, at least prima facie, they ought to be accepting the effects of the courts of the seat fulfilling their function under the convention and accepting that is the way in which the convention architecture works.
My Lord, the answer is yes, but it's
So
not,
subject to your exceptional
but it's not
situation.
stated as such in the convention.
Right, okay.
That kind of consideration is left to each contracting state because, as the materials show, when you were dealing with so many different countries with different systems, they obviously legislate at the lowest common denominator, and they leave discretion on many points to each contracting state. We see that in various parts of the convention. So, for example, Article 3 of the New York Convention, which I'll take you to, is the obligation to recognize and enforce awards. But it's made subject expressly to the rules of the country in which the recognition and enforcement is being sought, because they couldn't deal with all the details of the circumstances, the procedure, the way in which it would be done. So it's left to each court. That becomes a very important point for this case, because the Court of Appeal was offended by a number of the aspects of the application in Pakistan, references to things that are common ground, its understanding, which we deny, that this is a preemptive application, it's our approach to partial recognition and enforcement. And it answered those issues by reference to English law. But Article 3, importantly, gives that discretion to the recognising and enforcing court. It's for them to consider how to implement the treaty obligation to recognise and enforce an award, and that's Article 3.
And one can see that once the enforcing court has decided to treat it as a judgment of its own courts,
yes,
that then brings with it, presumably, all the potential for seizure of goods and corporate insolvency if they refuse to pay.
Yes.
So that does bring with it the sort of the might of the state, which you might think they should be able to decide whether to engage or not.
My lady, that's right, but if I can just be even more precise, there are three stages or three concepts at play. Firstly, recognition of an award. Secondly, enforcement of an award. And thirdly, execution. The New York Convention legislates on the first two, recognition and enforcement. Then, when you've got enforcement, you get to execution. And as my lady says, that's, of course, all the local powers of compulsion and seizure of assets, etc. Recognition means using an award defensively. For example, to raise a res judicata and stop somebody relitigating something. Enforcement is the multitude of ways in which you bring the award into local law and make it effective. Most notably, converting it to a local judgment. And that process of converting it to a local judgment is what we're concerned with here. And that is, even in that, before you get to execution, the Convention gives discretion to the recognizing and enforcing court as to the procedure for that. Will it be preemptive? Will you allow partial, etc.? That's all up to, through Article 3, that's up to the recognizing and enforcing court. With an apology, I wanted to make one point on issue estoppel. Can I go back one step just to complete the point I wanted to make, just to flesh that out? I'd ask the court just to bear in mind, even if one were to look at issue estoppel, which is exceptional and in doubt, very much in doubt, even in this country where we have one first instance decision that has applied an issue estoppel, that's the Diag case, Mr. Justice Eder.
Sorry, the name of the case.
Diag, D-I-A-G. Diag and Czech Republic, I think. That's the only case we've got, and we've got reason to argue why it's wrong. But in any event, he recognized you're very unlikely to get an issue estoppel on public policy and arbitrability, which is Article 5.2 of the New York Convention.
Well, those are intrinsically local questions.
Yes, and those are the ones that are in play in this case.
Or primarily, anyway.
Yeah, primarily. Sorry, that was the point I wanted to make before. So those are classically cases for, if you're arguing about Pakistan public policy, that's not going to be an issue estoppel question that's going to bind Pakistan or bind anybody else.
Yeah, almost definitionally, it's not the same issue. So.
Exactly, it's not the same issue. So where this takes us, still in my overview, is what's the approach of the court to an anti-suit injunction? And our test that we have articulated is on the following principle, which is we fully recognize that if you go back to my graphic, the courts of the seat on one side of the line are absolutely entitled to protect their area up to the line. Absolutely entitled, and that's C versus D. Anything that happens abroad, which should have happened on that side of the line in England, could be the subject of an anti-suit injunction. So if you're going for an erga omnes remedy outside from the seat in another country, you've crossed the line. Because that's definitionally, conceptually, that's something you must do at the court of the seat. That's their job. Anything which is going to try and nullify the award itself for all time, for all territories, you can only do at the seat. But what's happened in this case is the remedy that's being sought in Pakistan is not erga omnes, and it couldn't be. Because unlike previous cases involving Pakistan entities which were cited in the Court of Appeal like Atlas, these are old cases under the 1940 Arbitration Act in Pakistan, which is the old legislation, which allows setting aside for misconduct and whatever else. In this case, the application in Pakistan is under the 2011 New York Convention Act in Pakistan. And that means as a matter of Pakistan law, and Pakistan binding Supreme Court authority, which I will show you, we cannot ask the Pakistan court to set aside the award. The only thing we can do in Pakistan is to ask the court to recognize and enforce or not recognize and enforce in Pakistan. That doesn't say anything about how that award would be treated anywhere else. So we say it's squarely on the other side of the line. And the error in this case is to try and expand the supervision of the seat court, England, across that line and interfere in 171 other countries' application and implementation of the New York Convention. If there's a problem with what we're doing in Pakistan, It's for the Pakistan court to reject what we're doing, to dismiss our application. In the same way as if you were to turn the tables and it was a New York Convention application in England, we wouldn't be accepting a foreign court telling us how to apply the New York Convention. We'd apply it according to our understanding.
So if it really were the case that the Pakistan courts were seeking to produce an order intended
Yes.
to have erga omnes effect,
Yes.
it would be a C&D case.
Yes, it would.
And
It would.
An anti-suit
Yes, it
injunction could lie.
Yes.
But you say it's not that case.
Yes. So, and I should say that we have explained...
Can I just ask about the terminology?
Yes.
Erga omnes, is that a well-established
Yes.
terminology in this
It
area?
is.
Yeah,
It is. So you see it a lot all the way through. But it is a shorthand, because erga omnes, I mean, it could mean anything. What we're using it as a shorthand, and what we mean by it is remedies that are available at the seat that are focused upon the award as an instrument for all purposes, regardless of territory. And that would be a setting aside, could be a remission back to the tribunal, a variation. We have gone through in detail the remedies of...
I find it slightly misleading description because it suggests that it's telling you something about the effect of the court's order, but your point is really about the nature of the remedy
Yes.
that you're seeking from the court.
Yes.
And what effect other courts may give to that
Yes.
is not necessarily concluded by what the court of the seat does.
Yes.
So suppose that the arbitral award had said it's 10.36 rupees per kilowatt hour, and then it became apparent there'd been a mistake in the arithmetic, and the court, but the arbitrator refused to deal with it. The court of the seat then varies it and says, actually, if you do the maths, it comes out at 10.39 per kilowatt hour, and therefore they vary the order.
Yes.
Now, what is it, I'm still trying to understand, that if the person who wants to enforce it to get the 10.39 takes it to an enforcing court, what is it that stops the other person from saying, no, it should only be 10.36 because that's what the award said, and we ask you to ignore what the Court of Appeal and the court seat said? What I understand you to be saying
Yes.
is there's nothing actually in the convention that prohibits the enforcing court.
Theoretically,
Yeah.
an enforcing court would have a discretion, it says may, to take the course that my lady's suggesting and say, well, we're going to disregard the seat court and we'll just enforce the award. But in the main, that's just never been accepted. It's always been accepted, and I know this sounds vague, but it's been accepted always that the seat court is the supervising court, and because Article 5 of the New York Convention, 5.1e, says that a ground for refusing recognition and enforcement is something the seat court has done, and Article 6 of the New York Convention provides a provision that if there's a pending proceeding at the courts of the seat, that would be a basis to stay. So the understanding has always been that it's the seat court's in control.
No, I understand that. I just want to be
Yeah.
absolutely clear in my own mind that
Yes.
you're not saying that there is something in the convention itself which says, oh, contracting states, when you implement this in your domestic law, you must provide that your courts respect a variation made by the
No.
seat court.
But all the Travo, all the commentaries, all the...
No, I understand
Yes,
that.
yes,
You've answered
yes,
my
yes.
question. Thank you.
Just to finish off, again, at the general level, we have explained, and I will explain to this court, what we're doing in Pakistan is not a setting aside. We do not seek any relief beyond the question of the effect, if any, to be given in Pakistan. That includes the injunction that we're seeking, which I will explain in detail as to how it works. But the intention for that not to go beyond Pakistan. It's simply a way of enforcing a particular finding in the award. But we've also given an undertaking, offered an undertaking, that if there's any doubt about it, we are prepared to change the relief in any way to make that clear, to undertake that we do not intend any effect beyond Pakistan.
And where do we see that undertaking?
That's in the last part of my written case. And an undertaking that to vary, to say in terms, we do not seek a setting aside. And indeed, if the court wanted to go that far, we wouldn't apply for an injunction.
Sorry, just help me with your written case, just so that I can see.
The very last page, 92.
Page 92.
You have sort of various layers of retreats, if needed.
I'm not conceding it's a retreat, but clarification.
So these undertakings are not offered conditionally.
No.
They're
Absolutely.
full undertakings to the court on.
And the reason we're doing this is because, if I just speak rather frankly, I had what may be described as a tough time in the Court of Appeal. The Court of Appeal took a view that we are up to no good in Pakistan. They took a view that we're playing around. All we're trying to do is what has happened in many cases previously, like Atlas, where you're just trying to set aside an award abroad. And there's a long, rich history of that. That all happened in Pakistan and India, by the way, under the 1940 Act.
Well, I can't remember what was under the original prayer, but you were using the word nullity.
Yes, and I'll explain that. There is the word nullification in the prayer, but you can only read it as being nullification for the purposes of arbitrability public policy in Pakistan. That's the full sentence. And I will explain that. But if there is difficulty...
It is a step on the way to a conclusion about recognition and enforcement,
Yes.
the way it's phrased, but still, it's a
recognition,
rather
but not
unfortunate term.
It is an unfortunate term, absolutely. We've accepted that. And there are, terms are used differently in different jurisdictions with different traditions. And maybe the discipline isn't there as it is here. But anyway, we've undertaken to delete that. The point I'm simply trying to make is that if there's a bad smell about this case, it's unfair, because we're being absolutely upfront that we are not seeking a setting aside. We are only going under the 2011 Act, asking the Pakistan court to rule upon the effects, if any, in Pakistan. That's it. And that's something which should be left to the Pakistan court as a contracting state in a multilateral treaty. It can't be assessed and prejudged by this court as the supervising court, and in particular, as I'm just about to show you, it can't be done through the prism of English law and the English interpretation in your convention. I think that takes me to the Judge Pelling case, if I can just show you what has now happened since the Court of Appeal judgment.
Right, so we're looking at this is a sort of interorum mission by
It is.
You're saying this shows how wrong it's got.
It is.
Can I just ask you this? Had you been seeking setting aside,
Yes.
either partly or wholly,
Yes.
are you conceding that that would have been unacceptable?
I am.
Right. And you're saying, I mean, was that clear before the Court of Appeal?
I made every attempt to make it clear, my lord. I mean, the Court of Appeal...
Because they're coming at this on the grounds that this is a full-throated attack on the award.
Yes.
And you might say, yeah, because it looked to them as if you were trying to get rid of the award.
Yeah.
At least in some fundamental respects.
Yes. And we're not. And that's something which they did not see. And what they...
Did you give the same undertakings to the Court of Appeal?
We gave the same alternative relief, and that's addressed in the last part of the Court of Appeal judgment.
Right.
And they simply say this is still somehow a setting aside. And the particular point, which I think, my lord, with respect, is so important, was not picked up at all by the Court of Appeal, which is we're going under the 2011 Pakistan Act, not the 1940 Pakistan Act. So as a matter of Pakistan law, it's legally impossible, unless the Pakistan court gets it wrong. We cannot ask for a setting aside under the 2011 Act. And of course, there's a comity question. Does this court assume that the Pakistan court is going to get their law wrong? That is not addressed anywhere by the Court of Appeal.
So just going back to my example a minute where they varied the amount.
Yes.
So do you accept, following on my lord's point, do you accept that if somebody then went to their own enforcing court and said, we want to enforce the unamended number that was in the award and ignore the court of the seat, could an anti-suit injunction properly be issued by the court of the seat to prevent them doing that?
No, certainly not. Because that's a question on, if you forgive me for going back to my graphic,
yes.
It's on one side of the line.
It's on the enforcing
It's on the
side.
enforcing side. But the minute that question creeps over the line, then yes.
But it wouldn't be creeping over the line to try and ignore
No.
this.
Because Because the question is, what are you asking for? And if you're only asking for a determination as to the effects, if any, in that jurisdiction, that is the preserve of that court. But if you're asking for more than that, which is take the arbitration award as an instrument for all purposes, then you've crossed the line. And that's a very clear, easy line. And it's the essence of double control. That's the architecture of the New York Convention, which was known to the drafters. All these issues, they were addressed at the time, because there was always a question, how do you match two types of control? How do you allow them to live together? And in the course of the drafting of the New York Convention, there were proposals that were made to say everything should be the courts of the seat. They should have the final say, and that was rejected. Then maybe it could just be the enforcement court, obviously rejected. And so the balance that was struck in the end is the line that I have depicted. Can I make my interim submission?
Sorry, just before you get there, I'm sorry to interrupt.
Yes, no, not at all.
But if you go back to page 150 of the electronic bundle and the Court of Appeal decision, paragraphs 67 and 68,
Yes.
it's pretty clear that Lord Justice Phillips did not see the undertakings that were then being offered as going so far as to rule out the possibility of seeking nullification of the award.
Yes.
So you were offering different undertakings.
We're offering more undertakings now, but the core of it, the amendment, is the same.
Right.
That's I think the second or third alternative we've got in our written case.
Right, but his last sentence clearly, this word nullifying was clearly very important.
Nullifying doesn't appear in the wording of 67.
No, it doesn't.
So that the part of that undertaking was to take out the word nullifying.
But it still says that Star Hydro will be permanently restrained from issuing any invoices.
Yes, that is within Pakistan, and if that needs to be clarified, we'd say within Pakistan. And I will explain why that is, because again, that's enforcement of a particular declaration in the award, but it's with no intention whatsoever for that to go beyond the territory of Pakistan. It's simply what effect, if any, in Pakistan will this award be given.
So you say the last sentence of 68 is just fundamentally incorrect?
Yes. And it's incorrect as a matter of Pakistan law, because the 2011 Act doesn't allow for that. I have another, if I may say, I have another objection to that last part of 68, which is what the Court of Appeal has done here is to look at any other relief and to assume bad faith on the part of both us and the Pakistan court. Any other relief is something which is standard boilerplate.
Yeah.
I think what the Court of Appeal is saying here is that we can't be trusted, and nor can the Pakistan court be trusted, because any other relief might allow them to do something else. That's no way to proceed with respect to the Court of Appeal. You can't, and especially in the context of a multilateral convention where the UK has agreed to Pakistan being a competent authority, as well as all the other 171 countries. We've agreed in a treaty that our fellow contracting states will implement and apply this treaty. So the Court of Appeal was absolutely wrong to say, well, we can't allow this because that phrase might allow the Pakistan court to breach the New York Convention. And again, there's no evidence before the Court of Appeal. There's nothing referred to the 2011 Act. How could it do it? And anyway, how can we assume that?
And it would be, well, in my experience, the sort of standard phrase that you'd use here as well. That there are
Just stick it in at the end in case so that it comes out at the hearing you've forgotten something.
Yeah.
It doesn't usually do you much good then anyway.
Exactly.
Because you should have put it in there more specifically.
Exactly.
Okay, interorum.
Interim.
It's not entirely interim,
not
because you're
entirely.
presumably asking us to hold that this case was wrongly decided.
Because
Yeah, but
Yes.
I think you're showing it, as I understand, you're showing it to us to say this it shows how things can go, how far
two
things can go
things.
wrong.
Firstly that, but also it shows Judge Pelling the way that he clearly sets out what he sees as the impacts, the analysis of the Court of Appeal, how he's getting there. And that's important because it's now stretching C versus D. C versus D is this seminal linchpin case. That's the one upon which we have Atlas and Enker and many other cases rely upon to say that the seat court has the ability to enjoin anybody trying to set aside abroad. And what now is being done is the wording of C and D is being stretched, and that's where this is leading to all sorts of problems. And that's clear from Judge Pelling's case. So if I can just go to that. The case is Integra, Petrochemicals and BASF. It starts in the bundle at 1869. This came out September 2025, so pretty soon after the Court of Appeal judgment. I'll just quickly paint the facts. It was a dispute as to whether or not a sale of biomethanol had been concluded. That was the question. There was an arbitration in London. A sole arbitrator held the contract had been concluded. And that meant that the party called Integra was successful. BASF was saying there was no contract, and they could have challenged that under Section 67 and 68 before the London court as the court of the seat. But they didn't. They didn't challenge it for a number of reasons to do with funding and various other things. But all one needs to know is they didn't challenge it. And time ran out so that they were no longer able to challenge it in London. So what then happened was BASF commenced proceedings in Germany under the New York Convention. And we see that at page 1872. Paragraph 8. And if I just read the beginning of that, on the 4th of June, 2025, BASF commenced the German proceedings. The document by which the German proceedings were commenced is entitled Application for Declaration of Non-Recognition of the Foreign Arbitral Award. So this is what's called a preemptive application by an award debtor under the New York Convention to the German court as a contracting state under the New York Convention to not recognize in advance of any application being made by the award creditor. So there's no application to recognize and enforce by Integra, but this is started by BASF to say you can't recognize it. It's common ground, as we see from paragraph 9, that preemptive application is acceptable under German law. So the Court of Appeal in our case said you cannot have preemption under the New York Convention, but that's just not true. Many countries, a number which we've cited in our written case, do allow it. And that's up to them. That's the way that they implement the New York Convention. And that goes back. I
mean, for what it's worth, we might do that here.
Yes.
Because it's just
Absolutely.
an aspect of the width of our declaratory
Absolutely.
relief jurisdiction.
Yes. And under Article 3 of the New York Convention, you have an express reference to the rules of the country where recognition and enforcement is sought.
Rules of procedure.
Rules of procedure.
This is procedure.
Yes.
Yeah.
Yes. And we've got a commentary by Shearer we've put in, which says that in terms that a good example of the rules of procedure in Article 3 would be whether or not to allow preemptive applications. Again, I can give you that reference when we get to that. So if one then goes to 1873, the ground which was being deployed in Germany was, you see this at the bottom half of that page, beginning at page 73, BASF summarizes the merits of its application. And if you would just scan through that, what they were relying upon was Article 5.1a of the New York Convention to say that there was no jurisdiction because there was no agreement concluded. So it's the same ground that they could have brought under Section 67 at the seat, but they didn't. At page...
Well, it's the sort of case where you can potentially argue the same point time and time again in lots of different places.
Correct.
Where first of all, the arbitrator decides whether he's got jurisdiction, and then every other court decides whether he did or didn't.
And it sounds cumbersome, and it sounds inconvenient, but that's the structure of the architecture of the New York Convention because of double control.
It's a recognition of, well, the sovereignty of the receiving
Yes.
state, that they're entitled to apply their own filters as well.
Absolutely. And again, going back to the Travo, those states would not necessarily have agreed to apply their sovereign powers of compulsion unless they have control.
That control, yeah. So it's just fundamental. You say fundamental to the bargain under the convention.
It's fundamental. And I'm just going to take that just one increment further.
Yeah.
Article 5 is split up into two groups of defences, 5.1a and 5.1 and 5.2.
Could you give us the reference just so we can follow
Yeah.
the point you're making?
3841. Sorry, this is a slight diversion, but it's relevant.
Yes.
So Article 5 is in two groups of defences, 5.1 and 5.2. The point that my Lord has put to me about the sovereign discretion is even more heightened when it gets to 5.2, which is relevant in this case, and that's on arbitrability and public policy. Because that is so sensitive, that is something which the state, the recognising and enforcing court can raise of its own motion, sua sponte. So it's not dependent upon any party raising it, whether it's award debtor or award creditor, anybody.
Sorry, and where does one see that in Article 5?
5.2, if you look at the chapeau of 5.2 and compare it to 5.1. 3843. Thank you. 3843.
I think that is an inference drawn from the fact that it doesn't have the words about the request of the party
Yes.
against whom
Yes.
it is invoked.
Yes.
Right. I
Yes,
follow.
thank you. Can I go back to the BASF case? So at page 1875, actually, the discussion starts at 1874. So, sorry, just to complete the facts. So this application is brought in Germany, and Integra then approached the English court for an anti-suit injunction to stop this happening under the New York Convention. At the bottom of page 1874, we get the heading discussion. Going over to 1875, if I can just pick up about 7 or so lines from the top. The judge said, as a matter of English law, if the court has that, as a matter of English law, by agreeing to English law as the curial law of the arbitration, the parties agreed that any challenge to the award was to be made in the English courts, save to the extent otherwise permitted by English law. And that is the crux of Merlin and Friends case, and it's the crux of the Court of Appeal reasoning. It's the statement in C and D that any challenge to the award was to be made in the English courts, save to the extent otherwise permitted by English law. And that, what I'm going to show you, is a misreading of C versus D. As it happens, C versus D was not about New York Convention. It was only about that side of the line, which is the preserve of the courts of the seat. And I'm going to show you, the New York Convention was expressly carved out of C versus D, both at first instance and Court of Appeal. They made reference to the New York Convention and said, we're not covering that.
There's a slight wrinkle here, which is that actually the arbitration agreement is agreed to be governed by Pakistan law. It therefore seems to me that strictly the question of what the parties agreed to do should be determined in accordance with Pakistan law, although, as I don't think we've got any evidence, whether we're probably assuming it's the same as English law.
Yes. But the question here is not just within to be characterized as what was agreed in the arbitration agreement. It's also the English courts as the lex fori, its interpretation and application of a convention, what its approach is. Because, as I'll just, if we just go down, just to the bottom of page 1875, where we are, there's a paragraph beginning, this principle has no impact. If you just go down 3 lines, it says, 4 lines, I qualify this proposition by reference to English law because by choosing London as the seat of the arbitration, the parties may be taken to have agreed that proceedings on the award should be only those permitted by English law.
Well, what they should be taken to have agreed is a matter of construction of their agreement.
Correct. Which
must be governed by the law of the arbitration agreement.
Correct. Oh, that's correct. Then, if I can take you, please, to page 1877, at paragraph 15. As a matter of English law, therefore, the starting point is that any challenge, I put emphasis on those words because that's important for my learned friend, any challenge to an award can only be those permitted by the Arbitration Act 1996, and then they cite the Court of Appeal in this case, Judge Pelling cites. And then just dropping down about 5 lines, there's a sentence beginning, to the general principle identified above, there is an exception which enables a party to an arbitration seated in England to challenge awards in the circumstances permitted by the New York Convention, but only to the extent recognized by English law for the reasons identified by Longmore. With all due respect to the learned judge, that is a bizarre proposition. It's not in C versus D anywhere. And what was then found was that by the learned judge was that English law does not allow preemptive applications. That's an application by an award debtor under the New York Convention. And therefore, for that reason alone, the German proceedings were impermissible. But Germany, for more than 60 years, has allowed preemptive applications under the New York Convention. So what's happening here is, because of the Court of Appeals approach, the learned judge says, when you're dealing with a New York Convention application, you interpret the New York Convention by the law of the seat, England. And that allows the English court, albeit indirectly, to tell Germany it can't do what it's always done with its implementation of the New York Convention. And that approach answered what we've called the merits issues before the Court of Appeal in this case. The Court of Appeal, as Starr does now, addresses each of the points which they don't like in the Lahore proceedings by reference to English law and English practice, like, is this partial recognition enforcement? Can you sever the award? Is it preemptive? Can issues of common ground be recognized and enforced? Is motivation relevant? Now, all those questions are now, through the Court of Appeal, subject to English law. The court says, English law says this, and therefore what you're doing in Pakistan is improper. And therefore
So that was the jump that you say was made in, well, they think they say there were two jumps.
Two jumps.
First, moving it, allowing anti-suit injunctions when they're not seeking as erga omnes as it gets under the New York Convention. And then the other is not allowing relief, not allowing someone to apply for relief in an enforcing court if that relief would not be available.
Correct.
If you were trying to enforce a foreign award in England.
Correct. We do say, although those are two separate issues, they're springing from the same source, which is overly expanding the role of the supervisory court.
Yeah.
And that totally undermines the New York Convention architecture and double control.
I'm not aware it's ever been suggested here that when somebody's trying to enforce or recognise an arbitration award made in a foreign country, that we should be looking at the law of that country and deciding whether they would recognise or enforce it to decide whether we should here.
Well, my lord, I was going to address you in some detail on that because this would represent a total sea change for the English court. Never, in my knowledge, I've argued a number of these, never in a New York Convention application has the English court looked at the law of the seat to interpret and implement.
I don't think so.
And it would change results that we know. I mean, I can give you some examples. Kebabji and koot, food. Kebabji was a case where the question was whether or not a general choice of law in a contract should be taken as a law governing arbitration agreement. The English court took a view on that in the context of a New York Convention application for recognition and enforcement and decided that it did apply to the arbitration agreement such that a particular party was held not a party to the arbitration agreement. Perhaps in a long, rich historical tradition, the French courts disagreed with the English court. And the French court is the court of the seat. So England having taken that view under the New York Convention, the French court hears an application at the seat as supervising court, and they say, no, a general choice of law governing an arbitration agreement doesn't extend to the arbitration agreement. The arbitration agreement is governed by the law of the seat, the forum. And so they apply a different law and say that party is a party. Now, assume for now that France has an anti-suit injunction jurisdiction. In this scenario, according to the Court of Appeal, the French court could enjoin the English court from the determination that it made in Kebabchi under the New York Convention, because it could be characterized as a challenge to the award in England, which would not be acceptable in France. That would be an extraordinary result. But that's what the Court of Appeal test does. That's what Starr's test does. Whereas I think the term is unfortunate, but what we've called the erga omnes test, the test that we have articulated is the one that preserves the essential architecture of the New York Convention and is absolutely consistent with C versus D. And that is, as long as the English court is only concerned with the effect of the award in England, it's fine.
But how do you tell whether it's only concerned with the effect of the award in England?
That is something which requires the court to have a look and take a view. And what the Court of Appeal, we had, in fairness, we had alternative cases in the courts below, where one of our cases was a little bit more extreme to say, look, if it's New York Convention, it says it, you can't even look. And we accept that's not right. It's not a silver bullet or labeling question. It is a question of substance over form, where the English court can take a view. And the English court's used to doing that, because in C versus D, that's what it does. All the cases following C versus D look at what is being applied for abroad. They do that already.
So if, for example, in Pakistan you were seeking relief to say Starr should not, to injunct Starr from issuing invoices in any country or trying to sue on those invoices in any country, then we could look at that and
yes.
say that is going further than
Absolutely.
you can.
Yes.
But what about, one more question, in my earlier example where the court of the, where there's one side thinks there's been an error in the computation of the amount, suppose there's no application in the seat to amend the order, but when somebody tries to enforce the order in a different country, in that country they say, no, there was this error, actually the award needs to be varied to change the figure. Where would that,
So
would we be able to issue an anti-suit injunction to stop them doing that?
It would depend on whether what's being asked is with the intention of an effect beyond that territory.
What you're looking at is what is the remedy that they're seeking. Is it enforcement, non-enforcement, recognition, non-recognition, or does it go beyond that?
Yes.
And then I think you're saying that we should look at what is the jurisdiction of the court being invoked, because if it's a jurisdiction to recognise or enforce, then that tells you the most that you could get there.
Yes. And that's why the Court of Appeal was very motivated, driven by the Atlas case. The Atlas case, can I say, from my point of view, for what it's worth, is unfortunate because it involved my client. Not me, but my client some years ago. And my client in the Atlas case went, for a London arbitration, went to Pakistan under the 1940 Arbitration Act and asked the Pakistan court to set aside the award, not having asked the Sikh court to do that. The decision, it was unfortunate for me because Lord Justice Phillips sat on that case and sat on the appeal in this case. And he obviously thought, you're playing games, you're doing what you've done before. But here's the key difference which my Lord has identified. Unlike Atlas, this was the 2011 Act. And to show that, we have put in the bundle the application that was made in Pakistan in the Atlas case. I'll just give you the reference. When you read through that application in the Atlas case, there are pages and pages of submissions to the Pakistan court on why the New York Convention has no application in that case, why the award should be treated as a domestic award in Pakistan, and therefore set aside for all time. It's page 505 in the bundle. So we've put that in to make the point that if you compare that to the Lahore application in this case, it's only under the 2011 Act. It's only framed in terms of the New York Convention. And therefore, it's a totally different exercise. And of course, it engages binding Pakistan Supreme Court authority, in particular the case called Taisai, Taisei, which again, I'll give you the citation in a moment. Taisai is the leading authority of the Supreme Court in Pakistan, which talks about the limits of the court's role under the New York Convention. It talks about minimal intervention. And
I think under the 2011 Act as well. You said under the New York Convention.
Yes.
That's under the 2011 Act as well.
Yes.
All right.
And so that's why it's not an Atlas case. And that's why, going back to my lady's question, it's perfectly possible for a court to take a view.
Do you have a page reference just for Taisai?
Yeah, Taisai is 2939, tab 123. I don't think tabs are helpful.
No, they're not. It's just
2939.
Thank you very much.
So, after exhaustive and exhausting submissions, I've reached the end of my overview. My lords, my lady, can I indicate where I was going to go, and we'll just see what perhaps may be of assistance. Having set out my graphic, what I had intended to do was just to show you some materials to make good the two different sides. Then to show you some materials on double control and how this concept, the two were married when the convention was drafted. That would then take me to the fact that this is all part of what we say is the arbitration agreement in this case. And that's important because you're dealing with an anti-suit injunction premised upon an alleged breach of the arbitration agreement, not vexation and oppression, which may raise other issues. So that's why it's relevant, because we say, frankly, you can't breach the arbitration agreement by going under the New York Convention if you've decided to locate your arbitration in a New York Convention contracting state. That's where I was headed, and then to look at the test itself that we are proposing and the particular objections that are being made against it. Then I was going to go to the Lahore proceedings in more detail.
It does seem rather counterintuitive that you describe this as a process that's rather cumbersome and inconvenient, that you have this convention, you get this award. You would have thought that the point of having the convention is that you can then go and enforce it quite straightforwardly without them being able to pop up and challenge it wherever you go. But you say, well,
no.
You've got 171 countries, they're a very mixed bag, this is all they were prepared to agree to.
My lady, perhaps one can think about this in context. You think about the difficulty that the world has had in concluding a judgments convention, and the sensitivity even with receiving a judgment from a court of one country into another. Now think about receiving an award from some unknown tribunal, who knows who they are, private individuals appointed to decide something, and you're asking contracting states on a summary basis to recognize and enforce by making it a local judgment of theirs to which they will apply their sovereign powers. I mean, that is, you're asking a lot. And that's why the Travaux are full of this debate about control. And one should just also get the context here. Before the New York Convention, there was the 1927 Geneva Convention. That was the forerunner. That was a very problematic convention. What it did for arbitration agreements and arbitration awards, in this case, is it said you could take your arbitration award around the world and get recognition and enforcement, but there was a requirement of what was called double exequatur. Double exequatur meant if you were the award creditor, your burden was to get enforcement and recognition at the seat first, or prove that that would be possible in order to get recognition and enforcement in any other country. That just didn't work as a system. It was cumbersome and it was complicated. So the revolution that is hailed with the New York Convention in 1958 was it got rid of double exequatur. So what you're doing by that is you are immediately taking away the primacy of the seat, which used to exist under the Geneva Convention, and you're giving instead control to all the other states. The only way that could function and would be acceptable is double control.
I think it's fair to say, though, that the point my lady raised is a matter of debate in the international, what you might call the international arbitration community, isn't it?
Yes.
And, for example, there's an article by Chief Justice Menon
Yes.
in Singapore, which is often produced, where he's suggesting that there should be issue estoppels recognised for judgments under Article 5.1, I think, and then the Article 5.2 should be left to sort of local. So he's trying to make proposals for a more cohesive international regime. So this is sort of an open issue, but it doesn't affect this.
It doesn't affect
the substance of what you're saying.
It doesn't. And my Lord, if I just add, Chief Justice Menon authored the India case in the Court of Appeal
in Singapore.
2023.
Right.
That was the case you told us about.
Yeah.
Which
And so he's making a distinction between an issue estoppel arising from a determination from the seat court and one arising from a determination of a recognition enforcement court. He said there was a dissent in that case, which was Lord Mance. But Chief Justice Menon said that there were grounds not, he doubted that it, and that was the difference. He said it wouldn't arise from a recognition enforcement court. This is page 3257. He would only be contemplating it from the seat court. And that tells you a lot about the different exercise that each court is doing, and goes back to my graphic. But in any event, as my Lord has pointed out, it doesn't affect anything in my submissions, because these are not, it's not New York Convention architecture, it's not the treaty itself. It's a debate under local law, domestic law, as to whether or not if they have issue estoppel, whether or not that might be a technique that they might use sometimes, and it's doubted by many people. If there was an appetite, perhaps later, I'll show you a portion of the travaux préparatoires of the New York Convention, which has not been cited by Mr. Justice Eder in Diag and Czech Republic. It wasn't cited even by the Singapore court, and it's flatly contradictory to the idea of an estoppel between seat and recognition enforcement court. Because when the New York Convention was being drafted, there were various models that were raised as possibilities, and one of them would have limited the say of each recognizing and enforcing court, and that was rejected.
yes.
My Lord, my Lady, we have a break in 5 minutes, I think, a 10-minute break for the transcript.
Yes.
I don't know whether...
We seem to have long breaks for transcript writers, and since it's been agreed, we will honour it. But I would say usually we don't have breaks for
No, I mean,
transcript.
I'd rather not. But it's a 10-minute break scheduled. I don't know.
We've been past. Patrick has said we don't have them because they can, if they need to catch up, they can see it on YouTube.
Yeah.
Or,
Well, I'd rather press on, to be honest.
yeah. Why don't we do
Yeah.
that?
We also have an AI generated transcript
Exactly,
ourselves.
yeah.
that we could
So I think the preference, unless my colleagues indicate otherwise, the preference from the bench is let's just keep going.
I'm grateful. So I've indicated where I was headed, but I think I can shortcut some of the steps.
Yes.
So my next step now is to just flesh out each side of my graphic. And that is, what is the nature of the powers at the seat court, just to show you some materials.
Yes.
And then on the other side, in contrast, recognition and enforcement.
So we're going to start with the seat.
Start with the
where
seat.
you're taking us now. Okay.
Can I ask you to look at the 1996 Act, just to show the English position? That's from page 947. So this is where we find the powers of the seat court for England. And the seat court, of course, will have powers before and during the arbitration. This is all in part 1 of the Act. Sorry, just to step back. The Act is made up of several parts. Part 1 is the court acting as a supervising court, where the seat is in England, Wales, or Northern Ireland. Part 3 is New York Convention, and that is the English court acting as a recognizing and enforcing court under the New York Convention. That's the split. Under Part 1, there are a host of provisions which show different things that the English court will do in its supervisory function. And they can be broken down into powers before and during the arbitration. So I just list some sections as an example. I know the court's familiar with it. Such as sections 12, extensions of time, section 24, removal of arbitrators, section 32, determinations of jurisdiction issues, section 44, court powers in support, etc. Then there's the second category, which is relevant for our purposes, and that's post-award. Once an award has been rendered in a London seat, the supervisory powers are contained, the primary ones, there are some ancillary ones. The primary ones are in section 66 to 69. So starting at 66 is recognition and enforcement, which is a domestic process for English awards, but it can be used for New York Convention awards as well. And we see that in section 104 of the Act.
So that's just to draw an arbitral award into
Correct.
the domestic English jurisdiction.
That's it. Then we've got section 67, that's at page 981. That is
Or did you say 981?
981,
Thank you.
and that's challenging the award on grounds of substantive jurisdiction. And importantly, you'll see the remedies that are available. 67.3, on an application under this section, the court may by order confirm the award, vary the award, remit the award to the tribunal in whole or in part for reconsideration, set aside the award in whole or in part, or declare the award to be of no effect in whole or in part. So those are, using the unhappy term, forgive me, those are erga omnes remedies. Those are all going to the award as a legal instrument.
Yeah, that's the more accurate way of putting it, isn't
Yes.
it?
Yes, regardless of territory. One needs a neater encapsulation of that.
Preferably in Latin.
Preferably, I mean, it allows someone to charge more if it's Latin.
Right. So that the effect of that is that you're not saying there's anything in the convention which stops an enforcing court dealing with an application that's asking for that relief, but we would issue an anti-suit injunction to stop that if somebody asked us to.
Correct. But sorry, my lady, just to be clearer, there's nothing in the award. Sorry, there's nothing in the New York Convention which provides for this. The New York Convention, the only remedies we're talking about in the New York Convention are Article 5 and Article 6, and that's grounds for resisting recognition and enforcement. That's all. There's no reference in the New York Convention to setting aside, remission, variation. That's just not within the powers on that side of the line in my graphic of a recognizing and enforcing court.
I mean, in a sense, perhaps this does go to the erga omnes point. If England is the seat of the arbitration and an English court issues an order pursuant to section 67 saying something has gone badly wrong, the award is nullity, that doesn't, as I understand what you're saying, doesn't strictly bind the court in a receiving state, where the person who's got the award, they still have the award, can take it to the receiving state and say, enforce this. I mean, the receiving state would have to look at how they should react to what the English courts have done, but they're not strictly bound by what the English... I'm summarising it correctly.
And correctly, if I may say.
Okay, thank you.
And we get that from the use of the word may in Article 5 of the New York Convention. So may refuse recognition and enforcement on the following grounds. And as I said before, we have these are exceptional, but there are some examples which we have, for example, like UKOS. In UKOS, it was felt that the Russian court at the seat had not acted fairly or was corrupt.
But we would issue an anti-suit injunction to stop somebody going to an enforcing court, asking the enforcing court to ignore what the seat court has said.
No. my lady, we would only, in my submission, the English court can enjoin foreign proceedings if they're on that side of the line.
Yes, yes. that's what I
If
meant.
they're trying to
They're
do in the
trying to
foreign
do-
court what
Yeah.
could be done under 67, so if they're trying to set aside the award. for
Exactly.
But in the example given, they wouldn't be trying to do that because
No.
it would just be the receiving court looking at an award, conscious in the example that the seat court has said some things about that award, but the seat court doesn't have the power to rip up the award and say it doesn't exist at all.
Yep. So what I'm doing by showing you these provisions is to really flesh out that side of the line as to what is the supervisory function.
And when you say fleshed out, I mean, you're looking, here we are looking at it through the prism of English law, which
Yes.
but you're using that as an illustrative example
Yes.
of the way this system...
This is an international standard. And the reason I say that with such sudden confidence is, no, it's nothing to do with me. The reason it's an international standard is it's based upon the model law. So there is something called the UNCITRAL model law on international commercial arbitration, which dates from 1985. And that is the international standard for national arbitration laws. That is now, it was set up as a model to be used by countries all around the world to reform their arbitration law. It's in the bundle at 3857. This is a very important document. What's happened now is, I don't have the figure in the top of my head, but it's a very large number of countries worldwide have adopted it, or have, like England, Wales, and Northern Ireland, have been heavily influenced by it and implemented its main features. And what we see here is is UNCITRAL model law. If you'd like to just allow me just another step on this. I'm going to come back in a moment to the UNCITRAL model law, because New York Convention was 1958, and it set up this regime for that other side of the line for recognition and enforcement. In 1985, the UN then decided to have a model for national arbitration laws, and they included two provisions in that model, Article 34 and Article 36. Article 34 of the model is what we're looking at here, setting aside at the seat. Article 36 of the model is New York Convention. For various reasons, they thought that should also be in the law, because not every country had a regime for recognition and enforcement. So that immediately raised the question of double control. You've got one model law, and you've got Article 34, which has got these provisions. Then you've got Article 36, which is New York Convention, recognition and enforcement. How do they sit together? And we see in the and the model, I should say, that the interesting thing about it, exactly, I'm being reminded, is that the grounds in Article 34 for setting aside an award are identical to Article 36. It's the same grounds. And it's the same grounds were copied from Article 5 of the New York Convention. And when we look at the travaux of the model law, I'll show you just two references when we get to that in a minute. It's again the same double control, which is these look the same. They both look, in the words of my learned friend, they look like a challenge of the award abroad, or anywhere, a challenge to the award, or an attack on the award. That's the language that's being used. But they are for totally analytically different purposes. Article 34 is on one side of the line. It's the seat. It's setting aside.
I mean, strictly, it's an attack on the enforceability of the award
Exactly.
as received
36.
in the receiving state.
Correct. That's the distinction.
It's just that to attack enforceability, one reason for doing so may be that you say to the court in the receiving state, this award should never have been made for particular reasons. Something's gone badly wrong with the award.
Correct.
But it's still, you're saying, as I understand it, that doesn't change the fundamental nature of what's happening in the courts of the receiving state, which is they're just looking at enforceability in their jurisdiction.
Correct.
So are you saying that UNCITRAL goes further, or doesn't go further than
Same.
It reflects.
Exactly the same. Exactly the same principle. And again, that wouldn't work. The analysis, the way that the UNCITRAL model will work, it wouldn't work on my learned friend's case or the Court of Appeal, because you've then got this idea that anything which can be construed as a challenge or an attack can be restrained by the seat. And that misses this distinction. That's sort of, in a sense, the core error that's being made here. The distinction between, my graphic is being ignored, and there's this higher general term being used of challenge or attack. The idea that the seat can protect from any challenge or attack. Can I, on that point, I wonder whether I can just quickly turn up my own friend's written case and just show you the way it's being put by them. It's about...
just so that I've got it in my head, I mean, you're saying that there is a congruence between the New York Convention, the Model Law, and our Arbitration Act, which I think you said was based on the Model Law. And you say, if you look at all these things, they're reflecting what you have told us is your graphic.
Correct.
Okay.
You'll see in the DAC report, which was the Departmental Advisory Committee report that was published alongside when the 1996 Arbitration Act was concluded and passed. It's all about the UNCITRAL model law.
Right.
It's an implementation of the model law.
Yeah, sorry, I interrupted you. Where did you want to go?
I'm coming away from the English Act, but I'm coming back to it in a minute. I just wanted to finish this point about, we're talking about attack and challenge. If I could ask the court just to turn up my learned friend's written case at paragraph 41A, which is page 109 of the key documents bundle. Just look at the breadth of the test that they're seeking. You have that.
Sorry, what paragraph?
Paragraph 41A.
41A.
Yeah. The English court's supervisory jurisdiction is not limited to restraining proceedings that must be brought under Section 67 to 69 of the 1996 Act. Rather, the English court's supervisory jurisdiction allows it to restrain any challenges to the award that are not permitted by English law, C, C, and D, and ENCA. An attack or challenge to an award is more than seeking set-aside or erga omnes relief in the foreign jurisdiction. It is seeking anything that could undermine any part of an award, such as also injuncting a party from enforcing the award or seeking in other proceedings declarations contrary. Now, that is an incredibly broad proposition which would destroy this architecture. You could say that, going back to the UNCITRAL model law, you could say Article 36 is an attack, it's a challenge. You're undermining the award.
And that's why you were emphasising that the grounds in Article 36 are the same as in Article 34.
That's the point. But they're there for a different purpose. And that's the distinction the Court of Appeal missed.
Presumably it's got an extra ground in 36 about the award being set aside under Article 34, as it were.
Yes. Yes, it does. So I said it's the same, but of course it's the same grounds. It's got that extra one because it's replicated Article 5 in your convention.
Yeah.
Yeah. My lords, I just took a slight sidetrack. Can I come back to where I am?
Yes.
Which is just to finish off for the completeness. I'm talking still about what are the powers of the supervisory court. I've taken you to Section 67. I just want to complete this by the full armoury that the English court has, which is consistent with the model law. English court also has Section 68, which is on page 983, and that's challenging the award for serious irregularity. So 67 was jurisdiction problems. 68 is procedural irregularity. And here, again, these are the same points that are covered by Article 5 of the New York Convention, but for a different purpose. And if you look at 68.3, you can see the remedies that are available. If there is shown to be serious irregularity affecting the tribunal, the proceedings or the award, the court may remit the award to the tribunal in whole or in part for reconsideration, set the award aside in whole or in part, or declare the award to be of no effect in whole or in part. And again, that's all erga omnes. It's not about territorial recognition enforcement. Just to complete this, we do have one oddity in English law, which is not UNCITRAL model law, and that's Section 69, which is there for historical reasons, and that's a possibility of an appeal on a point of law, which I think we're one of the last remaining countries to have that. But that is a non-mandatory provision which can be contracted out of, and in this case it was contracted out of by the application of the LCIA arbitration rules, so it's not relevant in this case. but it's relevant in terms of what is the armoury available at the seat.
Sorry, did you say that lots of countries do have it, or
No, they
that
don't. They don't. They don't. The idea, we have it for, this is a whole other topic, we have it because we've had it for many, a long time.
Yes.
But most countries, the Austrian model law doesn't have it. The idea is if you go to arbitration, there's no appeal at all. Because of our...
No, I understand. That's, I just...
So we kept it, but we kept it on the basis that it's non-mandatory. You can contract out of it at any stage. And if you apply the LCIA rules, as in this case, it's got in it, the rules say you can't appeal, so you've contracted out. Now, I had threatened the court with materials on the erga omnes effect. I can show you some of them if it's helpful, or I can just give you the references. I mean, there are...
Well, if you could, I don't know, show us your prime reference, and just to make the point, so we've got it in mind, and then perhaps you can just supply us with some references that we can...
Yes, well, so it's explained well in the starting point, Redfern and Hunter, which is one of the main textbooks. That is an excerpt, starts at 4474.
So you're now talking about commentaries that have made...
Well, I'll show you one commentary, and then I'll show you some decisions that refer to it.
All right.
So this is sort of the classic textbook on international commercial arbitration, and at 4475, this is paragraph 10.05 at the bottom of the page. It is right at the bottom. It is important at the outset to make a clear distinction between actions to challenge an award and opposition to actions seeking to recognise and enforce an award. A challenge to an award usually takes place in the courts of the seat of the arbitration. It is an attempt by the losing party to invalidate the award on the basis of the statutory grounds available under the law of the seat. In contrast, actions seeking to recognise and enforce an award, which are fully discussed in the next chapter, may take place in any jurisdiction signatory to the New York Convention, or one that has adopted the relevant provisions of the model law. In such actions, the party against whom recognition and enforcement is sought may rely on the limited exceptions contained in Article 5 of the New York Convention or the corresponding provisions of the model law to seek to block enforcement. And then the next paragraph, purpose of challenge. The purpose of challenging an award before a national court at the seat of arbitration is to have that court declare all or part of the award null and void. If an award is set aside or annulled by the relevant court, it will usually be treated as invalid and accordingly unenforceable, not only by the courts of the seat of arbitration, but also by national courts elsewhere. This is because, under both the New York Convention and the model law, a competent court may refuse to grant recognition and enforcement of an award that has been set aside by a court of the seat of arbitration. It's important to note that following complete annulment, the claimant can recommence proceedings because the award simply doesn't exist. And that last point, just pausing there, that last point is an illustration of this. If an award is set aside, it doesn't exist anymore, so you could commence a new arbitration. If an award is not recognised or enforced in a territory, it still exists. So you can't recommence another arbitration. And that's why I'm focusing on remedies that go to the instrument itself as a legal instrument, rather than its effect in a particular territory. There's one more commentary I'll just briefly show you, 4412, which elaborates on this point that I've just made. 4412 is an article by Professor Nazzini. Just to speed up, I'll just take you straight to the paragraph, if I may. This is under the heading Issue Estoppel and Abusive Process arising from previous enforcement proceedings. The role of the court at the seat of the arbitration is different from that of a court in enforcement proceedings.
Sorry, just give me the...
Yes, sorry, 4412. The role of the court at the seat of the arbitration is different from that of a court in enforcement proceedings. The court at the seat has supervisory jurisdiction in that it can entertain an application to set aside the award. If the award is set aside, the parties are no longer bound by it. the arbitrator ceased to be functi officio, and depending on the ground on which the award was set aside, fresh proceedings may start to determine the same dispute that was not validly determined in the previous arbitration. The setting aside of the award provides the successful applicant with a ground to oppose enforcement under Article 5.1e of the New York Convention. An enforcement court has a more limited role. It determines whether the award should be enforced in its jurisdiction. If the respondent establishes a ground for refusal under Article 5 of the Convention, the enforcement court may refuse to enforce the award, but the award continues to be legally binding on the parties. The arbitrators continue to be functi officio, and generally speaking, new arbitral proceedings cannot start afresh. Article 5 of the New York Convention is silent on the effect of a decision not to enforce the award in further enforcement proceedings, and the natural inference must therefore be that such a decision, unlike a judgment setting aside the award, is no ground for refusing enforcement in other jurisdictions.
Can I just ask a quick question on the first part of that? How does the UKOS case fit within that?
So the UKOS case is a refusal by this court to recognize a Russian setting aside.
Yeah, so Russia, it was the
Russia seat.
Yeah, so they have, the court has set aside.
Set it aside, and a party comes to the award creditor, comes to England and says, don't recognize, under our rules of private international law, don't recognize that Russian judgment is corrupt. And therefore, if you take that out of the equation, we have an award which you can enforce.
Right.
Still trying to enforce it now, as far as I know,
Yes.
aren't they?
Yes. Yes, all over the world.
So, I mean, when it says if the award is set aside, the parties are no longer bound by it, in a sense that
It
to
has,
an extent begs a question about what's happening in a particular jurisdiction if you do take the award and say, ignore the decision of the court of the sea.
I think the assumption here is the architecture working properly without corrupt courts.
Right.
And that's the basic structure. So the basic structure is, if it's set aside, it doesn't exist anymore. You have to overlay private international law considerations in each country if they're not going to recognize a particular judgment.
Right.
Doesn't change the architecture of the New York Convention. It just means in your instant case, you've got a corruption, which means that when you're putting it into the formula,
You ignore that bit of the effect. Yeah. But that, as you say, that is a sort of overlay or something more fundamental in terms of the operation of the rules of public international law.
Yes, but
at the level of whether, in that case, our courts would even recognise what has happened overseas as the action of a court, properly speaking.
But it's foreshadowed in Article 5 of the New York Convention because of the word may.
Right, okay. So the may preserves the...
So the may is page 3843. As ever in these fields, there's an awful lot written about one word, and may has generated a huge amount, but over the years. But there is a discretion recognised, may, and that means, and of course, going back to the point that I had made previously about having to get sovereigns on board, they had to have that let out.
Yes, but so strictly speaking, formally, the word may is significant because it preserves to the contracting states the power of their courts to apply their, what I was saying were the more fundamental rules of public international law for the courts of that jurisdiction.
Yes.
All right, thank you.
Could you give us at some point the reference to the UKOS case?
Yes.
That you mentioned a few times.
It's 2652.
Thank you.
There's also the Malicorp. We also have one other example in the bundle, which is the Malicorp case involving Egypt.
Oh, yeah.
Which is also the similar point. Again, non-recognition because of corruption abroad. 2045.
2045.
Yes.
Thank you.
If I can just take you to now away from the commentaries to some authorities. So we've got the Court of Appeal in Dalla as one example, and that is at 1335.
Sorry, an example of what?
A judicial a reference by a court to the distinction between seat and enforcement.
Yep.
So this is the Court of Appeal in the Dalla case, which was then upheld by the Supreme Court, page 1335, paragraph 16 and 17. This is in the judgment of Lord Justice Morbig. 16, the language of section 1032 of the Arbitration Act follows very closely that of Article 5.1 of the Convention, although in some respects its structure is slightly different. Sorry, just to pause, this was a New York Convention application before the courts for recognition enforcement. And then down to paragraph 17, Article 5.1e and sections 103.2.4 both recognize that the courts of the country in which or under the law of which the award was made have a supervisory role. The scope of the supervisory court's powers, and therefore the extent of that role, varies in accordance with its own domestic law, but will normally include the power to set aside the award in cases where the arbitral process has failed to conform to the terms of the arbitration agreement or has failed to meet certain basic standards of fairness. In some jurisdictions, notably our own, the court also has the power to entertain a challenge to the award on the grounds of an error of law. The power of the supervising court to annul the award is therefore of a substantive nature. It extends beyond the mere refusal to recognize or enforce the award, which is the limit of the powers available to courts of other states that are parties to the Convention. I had just randomly in my note just come across a reference that I had been asked for. My Lord had asked me for the reference of the First Media case in Singapore, which is the one that doubts issue estoppel.
This is Justice Menendez.
Yeah. And it is, the case begins at 3433, and it is paragraph 77 at 3453. My Lords, my Lady, that is dealing with now, I've dealt with one side of my graphic, which is the role of the supervisory court. Can I... I see. I have to correct one other reference. The UKOS case reference is 2639. They're two UKOS cases. Can I now switch to the other side of my graphic and look at the New York Convention in contrast to what I've shown you under the English Arbitration Act?
Completely my fault. I didn't write down the Singapore court reference.
Yes,
Give it.
so the reference is, it's 3453.
Thank you very much.
Paragraph 77. And it talks about the erga omnes effect intended at setting aside compared to the New York Convention. And then it asks the question, how can you have issue estoppel?
Right.
Yeah.
So in a certain sense, I think the Chief Justice analysis would be sort of leveraging off the supervising effect of the
correct
court of the seat and saying it goes this,
but not
further, but not the other way around.
Yeah.
And I think you, sorry to pursue this, but I think you told us you yourself in your submissions would not support that analysis.
No, and the reason is the travaux of, primarily, the travaux of the New York Convention, and the fact that it was almost precisely the effect was rejected when double control was established.
Yes, thank you.
I mean, I'm reminded that none of this really impacts, for our purposes.
No, we don't have to go there in this case.
No.
That's another case. Can I quickly then just take you through the provisions in your convention? I've referred to them sporadically, but just to do this a bit more methodically. So we now switch to the other side of my graphic, the limited scope of recognition and enforcement. New York Convention is at 3841. The New York Convention does two things, despite it has famously an incorrect title, because it talks about arbitral awards, but part of it deals with arbitration agreements, and that's Article 2. We're not concerned with that. So just looking now at its treatment of arbitral awards, if I can start at Article 3, which is at page 3842, and I've mentioned this a number of times already. This is the central obligation for contracting states to recognize and enforce awards. it says, each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon under the conditions laid down in the following articles. And that's the point I had referred to earlier about the discretion that is given to each contracting state to implement, interpret, apply the convention in accordance with its own rules of procedure. And if I may just drop an oral footnote, again, that's one of the problems with the Court of Appeal judgment and the judgment of Judge Pelling. It just blows that away. Then, what are the conditions laid down in the following articles? There is Article 4, which follows, and that's simply formal requirements, which you have to satisfy. You have to produce a copy, original copy of the award and the arbitration agreement. And then you get to the important Article 5, just down the page, which I've spoken about at length. And this has the same grounds of complaint as, for example, Section 67 and 68 of the 1996 Act. If you scan down Article 5, you are looking at complaints about the agreement not being valid, about lack of proper notice of the arbitration proceedings or the constitution of the tribunal, inability to present one's case, lack of jurisdiction, the award, etc. So it's the same ground, and if you recall my reference to the on trial model law, it's the same grounds. 34.
Articles 34 and 36.
36, correct. And then Article 5(1)(e) is the one which has a reference to the country under which the award was made. That's the seat. So 5(1)(e) has a defence. The award has not yet become binding on the parties or has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. You will note that there's no reference here to a fellow recognising and enforcing court. It's only the courts of the seat. And then 5(2) is the second group of defences that I'd identified earlier. Recognition and enforcement of an arbitral award may also be refused if the competent authority in the country where recognition and enforcement is sought finds that, and then the difference is not capable of settlement by arbitration or would be contrary to public policy of that country. So again, from the chapeau one can see this doesn't have to be raised by a party, this is raised by the court itself. And we see instantly then that the convention refers to two different competent authorities. It's got the competent authority in 5(1)(e), which is at the courts of the seat, and it's got the competent authority where recognition and enforcement is sought. And this just goes back to double control. And of course, in this case, we are concerned with 5(2), A and B, arbitrability and public policy, because it's my client's case that what the award is contrary to Pakistan public policy and not arbitral under Pakistan law. And then just to finish off, Article 6 is a reference to the availability to suspend, to adjourn proceedings for the purposes of Article 5(1)(e) if there are proceedings still pending at the seat. Again, there's no reference to proceedings pending in another court of recognition and enforcement, because that's not going to have any impact.
I mean, in effect, Article 6 is saying, since Article 5(1)(e) identifies clearly that a decision of the court of the seat to set aside, for example, is a relevant consideration for receiving court, if you're the receiving court, wait to see whether that relevant consideration comes to fruition or not.
Right. Can I then take you to some travaux of the on trial model law on double control? So I've shown you now the two different sides of my graphic. And you'll note that there's nothing in the New York Convention which gives you a remedy of setting aside or anything like 67, 68, or 69, of course. So I've explained to you the Article 34 and 36 of the UNCITRAL model law, two references in the Travo which just describe this issue of how they sit together. Can I take you, please, to firstly, the model law itself is, the relevant Article 34 and 36 is at 3860. That's where you'll see Chapter 7, recourse against award, and there's Article 34, application for setting aside as exclusive recourse against arbitral award. And you'll see there, if you scan down the grounds, they're the same grounds, procedural errors and excesses of jurisdiction. And then if you go further down to page 3861, there's a heading, recognition and enforcement of awards, which is a different chapter. And then you'll find Article 36, and that's on page 3862. And you'll see it replicates Article 5 in your convention. It's the same grounds.
Plus the extra ground corresponding to E.
Yes, yes. Can I then ask you to go to 3929? This is now in the Travo of the UNCITRAL model law. This is a March 1985 analytical commentary on the draft text. And this is discussing Article 36 and grounds for refusal. If you please go to 3938. Yes.
You say. Thank you.
There's, at the bottom of the page, after references, there's a heading commentary. And the heading is grounds for refusing recognition or enforcement of international awards. Paragraph 1, based on the prevailing policy considerations stated above, Article 36.1 adopts almost literally the well-known grounds set forth in Article 5 of the 1958 New York Convention and declares them as applicable to refusal of recognition or enforcement of all awards, irrespective of where they were made. And then if you go down to paragraph 3 over the page, that's 3939. The list of reasons seems also appropriate for domestic awards, although its correspondence with the grounds for setting aside entails the potential of what has been referred to as undesirable double control, i.e. two occasions for judicial review of the same grounds. This should be an acceptable consequence of the uniform treatment of all awards, based on the policy of reducing the relevance of the place of arbitration, in view of the different purposes and effects of setting aside and of invoking grounds for refusal of recognition or enforcement. A party should be free to avail himself of the alternative system of defenses, as such recognized by the 1958 New York Convention, also in those cases where recognition or enforcement happens to be sought in the state where the arbitration took place. As regards the potential risk of double procedures on the same grounds, it's submitted that these concerns are essentially met by paragraph 2, etc. So it shows you the flavor of this. This problem of double control has been there throughout, and it's always been dealt with in the way that I've identified.
And do we have the page reference for see below para 5? Oh, is that literally at the bottom of the page?
That's suspension of recognition enforcement. That's at the bottom of the page.
So just to be clear, whose commentary is this?
This is commentary from the Secretariat, the UNCITRAL Secretariat.
During the drafting process?
Yes, yes. It's 25th of March 1985, and later that year then the text was finalized. And another example of this, at 3940, you see the UN report of the working group that was tasked with drafting. This is now just a few weeks earlier, 6th of March, 1985, 3940. And at 3945, paragraph 153, the working group considered a proposal to insert, after paragraph 2, a new paragraph as follows. if an application for setting aside the award has not been made within the time limit prescribed in Article 34, the party against whom recognition or enforcement thereafter is sought may not raise any other objections than those referred to in this article. So that was, just pausing if I can insert some submission, that was an idea on how to do double control by saying, well, why don't you say that you can't go for recognition and enforcement unless and until you've actually gone to the seat.
Well, except in this article, paragraph 1, subparagraph say, well, it's not
all of them.
Not all of them.
Not all of
some
them.
of them.
Some of them. And the reason why some of them, because there was huge sensitivity about public policy and arbitrability, which came in the second group. But then if you go down to 154, on the same page, the prevailing view, however, was not to adopt such a provision. It was pointed out that the intended preclusion unduly restricted the freedom of a party to decide on how to raise its objections. In view of the different purposes and effects of setting aside and of invoking grounds for refusal of recognition or enforcement, a party should be free to avail itself of the alternative system of defences which was recognised by the 1958 New York Convention and should be maintained in the model law. Yeah, so it's rejected. Importantly, in this system of double control, it's recognised, in particular, it's recognised everywhere, but also it's been recognised by the Supreme Court in England. The seat is not given primacy over these grounds. So we see the same grounds for setting aside and for recognition enforcement. The seat is not given primacy. Can I take you to Dalla, please, on this? Because that was an argument that was put forward in Dalla and rejected by both the Court of Appeal and the Supreme Court. So firstly, in the Court of Appeal, at Dalla at 1336, this is the judgment again of Lord Justice Morbeck, paragraph 18. You have that?
Yes.
Miss Heilbronn submitted that the distinction between the powers of the... So I'm sorry, just to remind you, this is a New York Convention application in Dalla.
For recognition.
Recognition and enforcement, yes. So just to... yes, so that's just to position this. Miss Heilbronn submitted that the distinction between the powers of the supervisory court and the powers of enforcing courts naturally points to the conclusion that as a matter of policy, the Convention accords primacy to the supervisory court. In one sense, that is not controversial, because Article 5.1e itself recognises that the supervisory court has the power to set aside or suspend the award, a step which of itself entitles, but does not require, courts of other jurisdictions to refuse enforcement. However, there is nothing in the Convention to suggest that the supervisory court is intended to have primacy in the sense that enforcing courts are expected, much less required, to treat the award as valid and binding unless and until successfully challenged in the supervisory court. If that had been intended, Article 5.1 would have taken a very different form. In particular, it would not have given courts of other jurisdictions an unrestricted power to refuse enforcement in cases where defects in the arbitral process of the kind which it describes could be proved. On the contrary, it's well established, and indeed was common ground, that a person against whom an award has been made is not bound to challenge it before the supervisory court in order to challenge its enforcement in another jurisdiction. See Svenska, and the cases there cited. In my view, the terms of Article 5.1 read as a whole amply bear out submissions, Mr. Landau, that one of the fundamental principles enshrined in the Convention is that such a person is entitled to oppose the enforcement of an award on the grounds that it's not based on a valid arbitration agreement to arbitrate. So I'm showing you this to show that you've got grounds available for seat and for enforcement. The policy is the seat doesn't have primacy on that. And again, the Court of Appeal has given effectively primacy to the seat by saying whatever is available, if you choose a London seat, whatever is available or not available under your convention is conditioned through the prism of what's acceptable in England. And that is just not this structure.
It does make you wonder what the point of this convention is. It doesn't seem to have much function or help a litigant unless usually it works okay and you get your award and you can then take it. Because you can choose the seat of the arbitration, you can't really choose where you're going to enforce it, because you have to try and enforce it somewhere where the debtor has assets.
So-
but if they can just raise all these points
Yeah.
again, it does make me wonder what the value of this is.
Malady, can I quote paragraph 126 of ENCA? And these are the words of my Lord Legate and Lord Hamblin, they were quoting Redfern and Hunter, Vetter and Lord Mustill. And what they said in that judgment was, the New York Convention is, and I'm quoting now, the single most important pillar on which the edifice of international arbitration rests, and perhaps the most effective instance of international legislation in the entire history of commercial law. That's ENCA. The reason that was said, I would, in my submission, is because it is the single most successful private international law convention. It has 172 contracting states. What we're dealing with here are the odd cases where something crops up, but there's a massive activity out there of people who agree to a seat in a New York Convention jurisdiction, and then, unlike judgments, they have the benefit to take that award through 171 other countries around the world and get effectively summary recognition and enforcement.
And it usually works.
It usually works. And it's working. I mean, it's not to say it's not working in these cases. This is what it was designed to do. It's designed to pick up awards that shouldn't be enforced. There's a misconception. People say, and my learned friend says often in his written submission, about the policy of being pro-arbitration. The policy of pro-arbitration is not enforce every award, because some awards do not merit enforcement. And the New York Convention has a perfect balance on that. And as I said before, we have still struggled in the world of judgments to have anything like the New York Convention. It's the reason, it's often stated, it's one of the reasons why people choose arbitration in the first place, is because they have the New York Convention, which you only have for arbitration. I know we're pressing time. Can I just give you take you just to Dalla in the Supreme Court?
Yes.
And then that might be a convenient moment.
I mean, Dalla illustrates your point. It's another case where the English court decided the award wasn't valid, I think, and refused to enforce it, but actually the court of the seat, the French, decided it was. It's another Kababji case,
It's
isn't
part
it?
of the same rich tradition. And can I say that in arguing Dalla under the New York Convention, there was never a suggestion that the court should apply French law to interpret the treaty. It's an English question. So just to take you to the Supreme Court in Dalla, 1398. This is in the judgment of Lord Collins at paragraph 103, bottom of the page. Nor is there anything to support Dalla's theory that the New York Convention accords primacy to the courts of the arbitral seat, in the sense that the supervisory court should be the only court entitled to carry out a rehearing of the issue of the existence of a valid arbitration agreement, and that the exclusivity of the supervisory court in this regard ensures uniformity of application of the convention. There's nothing in the convention which imposes an obligation on a party seeking to resist an award on the ground of the non-existence of the arbitration agreement to challenge the award before the courts of the seat. So you can go off and do whatever is available for you. Rather than going before the courts of the seat, you can go to a New York Convention country and do whatever's available for you there under the New York Convention, as long as it's not encroaching across the line.
Which I think was the point made in the second of the commentaries that you showed us.
Yes. And I wonder whether I could just leave you with one further follow-up point. It's said against me about Dalla that Dalla had in mind two options, which is sometimes called a choice of remedies. The choice of remedies is if you are a losing party in arbitration, you can either take an active remedy at the seat and apply to set aside, for example, under section 67 or 68, or you step back and you can resist recognition and enforcement wherever that's sought under the New York Convention. And what they say is that we are not doing that in this case. We're doing something different, because they say we are going preemptively now for non-recognition, declaration of non-recognition in Pakistan. I just want to clear away this point. As we've said in our written case, and after lunch, if it's not a disincentive, I will address this. Our application in Pakistan is not preemptive. It is an application for recognition, partial recognition and enforcement, albeit along with that is non-recognition and non-enforcement. So it's not preemptive. But assume it is preemptive against me. As Germany shows from the Pelling case, different countries have different implementations of the New York Convention. And many countries, including Germany, for more than 60 years, allows a preemptive application under the New York Convention for a declaration of non-recognition and something is non-recognizable or non-enforceable. That remains a remedy that's available under the New York Convention. So this choice of remedies doesn't mean we can't do what we're doing if it is preemptive. It just means it depends on the local law, how they've implemented the New York Convention. And that's, again, the mistake of the Court of Appeal, which is to say, no, they're not allowed to do that because you look through the prism of English law. My lords, my lady, that may be a convenient moment.
Yes. So I'm just looking at the timetable.
Yes.
I think if you use up the stenographer breaks today,
yes,
and your opponent uses them up tomorrow,
yes,
that's a fair distribution of stenographer breaks between
yes,
you, if you're happy with that.
Yes.
By all means, come back and say that that doesn't work, but I think it does. Very well. We'll adjourn now. Resume at 2 o'clock, please. Yes, Mr. Lander.
I'm grateful. My lords, my lady, I'm continuing to complete my virtual graphic. And I'm on the side of the line, which is the New York Convention.
This is all still the overview in one
No,
sense.
it's not.
Oh, it's not. Oh,
No. We've moved on from that.
to the end of that.
It
Right.
would have been a collective sinking in morale at that point. So, there are just a few areas of references I want to give you and some things I want to show you just to flesh out, again, now the right-hand side, or the other side of my graphic, which is the New York Convention side, as distinct from the seat. One of the consequences of double control is that the recognizing and enforcing court has adjudicative control over both the form and the substance of applications before it. So when you make an application for recognition and enforcement before a court in a particular country, it is that court that will have control over that application in terms of its form and in terms of its substance, and we say including its permissibility and its merits. So it is never for the seat court to try and dictate to a fellow contracting state's courts whether applications before that contracting state are permissible, whether they are correct in form or correct in substance. And that takes us back to the language that I took the court to this morning in Article 3 of the New York Convention, which we find at 3842, which is the reference to the rules, the rules of the state in question at 3842. I mentioned a commentary on this, which I now want to take you to, and that is a commentary by Professor Shearer, and that is at 4549. Starting at the bottom of that page, heading 5, application of the recognizing and enforcing states' procedural rules. Article 3 provides that recognition and enforcement of awards is to be made in accordance with the rules of procedure of the territory where the award is relied upon. Then over the page. It applies to both recognition and enforcement proceedings and grants states wide latitude in how they regulate such proceedings, provided that the limits otherwise contained in Article 3, discussed below, are observed. Indeed, the procedural framework for recognition or enforcement proceedings varies widely among contracting states. Some countries have enacted specific legislation addressing the procedural rules applying to the recognition or enforcement of convention awards. In other countries, the recognition or enforcement of foreign awards under the New York Convention follows the same procedures that apply to domestic awards. Finally, legislation in some countries provides that the recognition or enforcement of awards under the NYC is governed by the procedures applicable to foreign court judgments. The phrase rules of procedure is generally construed in a narrow sense, i.e. the lex fori is considered to govern only the practical procedural mechanics of award recognition and enforcement. This includes, for instance, the following points, which are discussed in more detail below in the subsequent sections. One, the types of proceedings and the manner in which they are conducted. Two, the limitation period applicable to bringing a recognition or enforcement action. Three, the country and court authority that has jurisdiction to hear such proceedings. And four, the provisional enforcement of decisions concerning the recognition or enforcement of arbitral awards, as well as the available legal remedies against such decisions. And then just dropping out to the next heading, types of proceedings and manner in which they are conducted. The lex fori determines the type of proceedings that may be initiated by the party seeking recognition or enforcement. For instance, the procedural law of the lex fori determines whether exequatur proceedings are possible or necessary before seeking to enforce the award. The lex fori also determines whether the award debtor may file for a preventative declaratory judgment rather than wait until the award creditor applies for recognition and enforcement. So, my Lords, may I show you that just again as going back to a submission I made this morning about the fact that it's built into the New York Convention itself, that it will be each recognizing and enforcing court that will take a view on the form of the applications before it. And that, again, is trespassed by the Court of Appeal judgment, which is saying, actually, you test that by the law of the seat. Similar statements are made throughout the materials. I'll give you references. There is the ICA, International Council for Commercial Arbitration Guide to the Interpretation of the New York Convention, at pages 28 to 29, and that's at 4232 to 3. Maybe paragraph references. Then there is the UNCITRAL's own Secretariat's Guide to the New York Convention, which is at 4171, and that is at paragraph 24. And there is a decision of the Canadian Supreme Court, we've put in the bundle, in the Ugraneft case. I'll take you to that. That is at 3584. Paragraph 19 of the Canadian Supreme Court judgment. Again, apologies, just for the sake of time, I'm diving straight into just a paragraph rather than setting the whole case out. 19, first, as a treaty, the convention, that's the New York Convention, must be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty, in their context and in the light of its object and purpose, Vienna Convention. In this case, the Convention's context and purpose provide indications as to how, in terms in particular, Article 3 should be read. The Convention's text was designed to be applied in a large number of states, and thus across a multitude of legal systems. And then just reading down beyond the references, one leading author has described the Convention as a constitutional instrument that leaves a substantial role for national law and national courts to play in the international arbitral process. The text of the Convention must therefore be construed in a manner that takes into account the fact that it was intended to interface with a variety of legal traditions. And again, that's entirely inconsistent with the Court of Appeal approach, which forces the prism of English law and practice as the way to interpret the treaty, entirely inconsistent with Judge Pelling's judgment, inconsistent with my learned friend's proposed test, which puts the seat at the center of the inquiry. My lady, my lords, the graphic that I have painted, probably now annoyingly, remotely, is distilled and brought together very, very effectively in my submission by a learned piece of writing by Professor Reisman of Yale University, writing some years ago. He wrote a book on systems of control and analyzed the very point that I've been submitting on in terms of double control under the New York Convention. In my submission is a very helpful distillation of my submissions up to this point. We find it in the bundle beginning at 4502. And I would like to just show you, if I may, just a few excerpts, starting at 4510. This is page 114. Professor Reisman says as follows, just picking up, it is in the first full paragraph, about halfway down, there's a sentence beginning, indeed, the legal effects.
Sorry, which page are we on?
It's page 4510 of the bundle.
Oh, yes, thank you.
So a sentence beginning, indeed, the legal effects, about halfway through the first full paragraph. Indeed, the legal effects which the Convention, that's New York Convention, assigns to the national judicial acts of the primary and secondary jurisdictions, just pausing there, that he means seat and recognition and enforcement, vary significantly. The secondary jurisdiction may only decide whether or not to enforce the award. The nullificatory consequences of decisions in secondary jurisdictions, if they can even be called that, are limited to this question of enforcement in that forum. But nullificatory consequences of decisions in primary jurisdictions have a universal effect. In terms of the dynamic of the Convention, once an award has been set aside in primary jurisdiction, it's not supposed to be enforceable anywhere else. Once a venue or a governing law is selected, the Convention gives to it a primacy with regard to the validity of an award. If an award is rendered, let us say in Switzerland, and is nullified under Swiss law, nothing should be enforceable in any other jurisdiction. However, if the award is rendered in Switzerland but enforcement is refused in France, where the award debtor has property, the French judgment should have no effect outside of France, even if it explicitly bases itself on a ground of nullity which would have nullified the award erga omnes had it been rendered in a primary jurisdiction. The award creditor may still seek enforcement simultaneously or sequentially in any other jurisdiction which is party to the Convention. The critical difference then is radius of effects. As opposed to the nullification of the hypothetical award in Switzerland, a nullification in France has no effect beyond France. And then, if I can ask the court, please, to go to page 4512. It is the onto about the third full paragraph, beginning the distinction between primary and secondary jurisdictions, is, in my view, central to the control system of the New York Convention and has been an important reason for the attractiveness of the regime to its various consumers. Limiting the effects of decisions in secondary jurisdictions provides an important protection for the winner and vindicates one of the key reasons for going to international arbitration. The parties initially sought the non-national, if not neutral, jurisdiction of their arbitration in order to avoid the potential bias of a particular national court or courts which might have a predilection for its national or affiliate. But arbitration is not an autonomous system. Because there's no international arbitral sheriff to enforce an award, those same national courts that could be skirted in the earlier phases must now be recruited for enforcement once an award is confirmed. And because the loser's national courts may be called on to enforce if the loser, as is likely, keeps substantial assets there, and because one of the parties' common purposes was to stay out of each other's courts insofar as possible, it is necessary to design a system which confines the radial effects of the res judicata of these secondary enforcers to their own fora in order to avoid the possibility of frustrating the entire arbitration. Otherwise, the loser could retreat to its own national courts, try to secure the nullification of the award there, and then use that judgment as a defense everywhere else. I was then just jumping the next paragraph, but one, But this control system must also have a primary jurisdiction. If no forum enjoyed the nullificatory power with universal effect according to primary jurisdictions under the Convention, the winner of a defective award could fail in enforcement in any forum and still continue to go to others in an effort at enforcement, harassing the other party and forcing it either to settle for a nuisance value factored by the number of jurisdictions in which it could be pursued, or to expend great amounts of time and effort to block and block again enforcement efforts without ever securing a terminal annulment. Such undesirable effects are limited if only one primary jurisdiction has the capacity to nullify an award. And then just lastly on 4514, after the quotation, there's the paragraph beginning, the possibility of the scrutiny of the award in terms of the standards of the primary jurisdiction, whatever they are, is an indispensable part of this control system. It's one half of the quid pro quo that is at the base of the implicit compact between primary and secondary jurisdictions. Without an assurance of the continuing possibility of such scrutiny at the behest of the loser, any secondary jurisdiction will be quite reasonably reluctant to buy a pig in the poke and to enforce an unsupervised private act, far less supervised than a foreign judgment, whose effectiveness requires the application of its own official power and whose consequence will be the removal abroad of the treasure of someone subject to local jurisdiction. So I think, forgive me for that long read, but that's quite an effective distillation of how double control works and how the two sit together and what the competing interests are.
I mean, I'd read that before and I hadn't really focused on what I now realise are important words on 4510. It's not supposed to be enforceable anywhere else.
Yes.
Is there anywhere where he refers to the limited effect even of a nullificatory decision in the seat court?
Meaning where an award is enforced even though it's been set aside?
Yeah.
No. Because when he was writing, that was just not known.
Right.
That is a relatively recent development.
But it's not that the wording of the convention has changed.
Not at all.
No, it
Not
never
at all.
did
No.
prohibit that.
No. On that particular point, I wonder whether I can just quickly take this as an opportunity. I gave a wrong reference this morning to my Lord Sales, I think with reference to the Singapore judgment that I was referring to. There are two. I gave you a reference and said it was about issue estoppel, a Singapore judgment. And I realized afterwards I gave you a wrong reference. There are two Singapore judgments that I referred you to. One is on issue estoppel, and that is the India DT case.
Is this the Chief Justice Menon point?
Yes. And that is at 3257. The relevant pages are 3295 to 3330. And that was on the point where Chief Justice Menon doubts that an issue estoppel could arise from one enforcement court to another enforcement court, as opposed to seat court to enforcement court. The reason I'm raising it now is because there's a second Singapore judgment, which I fear I gave you the reference to this one instead. But this one is relevant to my Lady Rose's question. And that is the case of PT First Media, a 2013 Court of Appeal decision from Singapore, Chief Justice Menon again. And that is at 3433. And the relevant paragraph is paragraph 77 at 3453. I wonder whether we can just turn to that. Paragraph 77. This is what Chief Justice Menon and his brethren said. You have that? While the wording of Article 5.1e of the New York Convention and 36.1a5 of the Model Law arguably contemplates the possibility that an award which has been set aside may still be enforced, in the sense that the refusal to enforce remains subject to the discretion of the enforcing court, the contemplated erga omnes effect of a successful application to set aside an award would generally lead to the conclusion that there is simply no award to enforce. What else could it mean to set aside an award? If this avenue of recourse would only ever be of efficacy in relation to enforcement proceedings in the seat court, then it seems to have been devised for little, if any, discernible purpose. As such, we do not think that in principle, even the wider notion of double control can encompass the same approach as has been adopted by the French courts. The refusal to enforce awards which have not been set aside at the seat court may therefore constitute one of the outer limits of double control. However, this specific issue is not directly engaged in the present appeal. We offer no further comment beyond these tentative thoughts. That is to say that it is a French oddity. French arbitration law has a different view about what gives validity to awards, and they have a transnational theory that awards can be delocalized, not connected to the seat. That is something which English law has rejected. As Lord Carr, I think Lord Justice Carr perhaps at the time, famously in the Bank Mellat case, said that awards are not free-floating in the transnational firmament. They are tied to the seat, and that's the English view. So, my lady, that may be a long answer, but just to say that the point that's being raised should not be given too much airtime. There are some jurisdictions that say, well, maybe if a seat court has set aside an award, we can still go ahead and enforce it. It's not the mainstream, and it's certainly not something one sees from the architecture or structure of the New York Convention as such. But there are theories on it, just as there are on issue estoppel. But in my submission, it doesn't impact on the case here. So I've now set out what we say is the architecture. The next step is just to mention what may be obvious, which is that architecture forms part of an arbitration agreement. When you conclude an arbitration agreement with a seat in a New York Convention contracting state, you are contracting into a normative framework which comprises the law of the seat, the arbitration law of the seat, and also the New York Convention. And I raise that, I make that point because, as I mentioned this morning, we're dealing here with an injunction on the basis that the fact that we proceeded under the New York Convention in a way that's not recognized in England is a breach of the arbitration agreement. And we say that can't be right. The reference to a normative framework is language taken from the latest edition of Mustel and Boyd, paragraph 3.1, which you will find in the supplementary bundle of authorities, SB2 at 5. And it's paragraph 3.1 of Mustel and Boyd, which talks about parties binding themselves by an agreement to a normative framework that comprises national and international arbitration law. It's an obvious proposition. I will mention that in this case, the parties actually had a specific provision in their contract about the fact that an award could be taken anywhere for recognition and enforcement. And that is section 18.5b of the power purchase agreement in this case, and the reference is 281. If you're at 281, you're in the power purchase agreement, and if you scroll to the bottom of the page, this is section 18.5b of the parties' contract. The company hereby unconditionally and irrevocably consents generally to the jurisdiction with respect to itself and any and all of its assets and property that it now has or may hereafter acquire of any court of competent jurisdiction for any action filed by the power purchaser, that's my client, to enforce any arbitral award or decision made pursuant to arbitration conducted in accordance with section 18.3. The company, that's Star Hydro, waives any objection that it may now or hereafter have to the venue of any action or proceeding brought as consented to in this section 18.5b, and specifically waives any objection that any such action or proceeding has been brought in an inconvenient forum and agrees not to plead or claim the same. So that's just to enhance the contractual point, because we're not dealing with vexation or oppression, that in this case, it is hard, in my respectful submission to the other side, to say that the fact that we have proceeded in Pakistan for enforcement and recognition is a breach of the agreement. Now, at this point, can I turn to the objections that Star Hydro now raise to what we have unhappily termed the erga omnes test, the test for which we're proposing. And there are a number of different points which they make, and I just want to address as many as I can in the time available. Firstly, and importantly, paragraph 29 of my learned friend's written case, they say that the erga omnes test is contrary to C versus D and ENCA and that line of authority. That's paragraph 29 of the written case. And as I said earlier, C versus D is the linchpin for all of this. But the point that has been missed is that C versus D, as I said earlier, was about challenges at the seat and erga omnes challenges. It was never about the New York Convention side of the graphic. It was never about defenses to recognition and enforcement. And so if I can perhaps ask the court to go to C versus D, firstly at first instance, and that is at 1183. If you allow me just to summarize the facts. This case involved a dispute on the Bermuda form of insurance. There was a London arbitration clause, there was a dispute and an arbitration in London. The losing party intimated its intention to apply to a federal court in the United States, applying US federal arbitration law, to ask for the vacation of the arbitration award on the basis that the arbitrators had manifestly disregarded the law. And the action was called a vacator of the award. The other side argued before the court that this was an English-seated arbitration, therefore English arbitration law applied as the curial law, and that therefore this was in breach of the other side of the graphic. This was a remedy of setting aside, and it should therefore can only be brought in London. You couldn't bring it in the US. At first instance, Mr. Justice Cook granted an anti-suit injunction on the basis, and this is the paragraph that is repeated all the way through, that by agreeing to the seat of the arbitration, the parties had agreed that any challenge to an interim or final award was to be made only in the courts of the place designated as the seat of arbitration. And that's the language that my learned friends rely upon. But the case only ever concerned the mandatory provisions of Part 1 of the 1996 Act. It was only about setting aside. It wasn't about challenging recognition and enforcement. So if one goes to paragraph 24, firstly, at 1192, Mr. Justice Cook there at letter E, just below, about 2 lines below that, says the mandatory provisions of Part 1 of the 1996 Act are listed in Schedule 1 and include Section 66, enforcement of the award, Section 67 and 68, challenging the award on grounds of substantive jurisdiction or serious irregularity, and Section 70 and 71, which include supplementary provisions. And then just by letter G, by agreeing to the 1996 Act, the parties thus prima facie accept the framework of the mandatory provisions. So that's what he has in frame. He's got in frame the remedies of setting aside, or the erga omnes remedies. Paragraph 27 at 1193. He says, as a matter of construction of the policy and the arbitration provision within it, with its express reference to English law and the 1996 Act, I consider that the parties have incorporated the framework of that Act and agreed that it should apply to any arbitration between them with all its mandatory provisions and with its non-mandatory provisions, save to the extent that there is agreement to the contrary. The agreement to the seat and the curial law necessarily imports that with the result that challenges to any award are governed by the relevant sections of the 1996 Act, as amended by the parties' agreement. So that's all he's focused on, are those kinds of remedies and challenges. Then at 47, 1198, paragraph 47, as I've already mentioned, the 1996 Act has express provisions which deal with the challenges to awards, whether for excess of jurisdiction, serious irregularity, or appeals on points of law. By Section 58 of the 1996 Act, an award made by the tribunal pursuant to an arbitration agreement is final and binding, but this is expressly not to affect the right of a person to challenge the award in accordance with the provisions of this part. That's Part 1 of the 1996 Act. Just to pause, he's not concerned with Part 3 or New York Convention, only Part 1. The agreement to the application of the provisions of the 1996 Act thus made the award final and binding, subject only to challenge in accordance with the terms of that Act, a point which is reinforced by the particular language of the arbitration provision, with its use of words such as finally and fully determined and final and binding. If one then goes...
So what's the relationship between Part 1 of the 1996 Act and the New York Convention?
None. Part 1 is
Part 1 applies to any domestic
any arbitration seated in England, Wales and Northern Ireland.
And how do you tell whether it's a New York Convention one?
The New York Convention has its own scope application, scope provisions, and so it will be, an award will qualify under the New York Convention if it has taken place in a New York Convention contracting state. There are provisions at the beginning of the New York Convention which say what it applies to, and the New York Convention is then reflected in Part 3 of the Act for awards that are coming into this jurisdiction from abroad. So, so the court is focusing on the...
And as I understand this reasoning, the question the judge is asking himself at this point is a matter of construction of the contract. It's just that the contract refers to the 1996 Arbitration Act, and in effect, contractually, they're saying that's it, so far as the remedial framework.
So you're stuck with the 96 Act. So now, what was being intimated in this case is very, very important, and that's at paragraph 13. So if you go to 1189, paragraph 13 of the judgment, in further correspondence, D intimated its intention to apply to a federal court applying US federal arbitration law governing the enforcement of arbitral awards, which was said to permit vacatur of an award where arbitrators have manifestly disregarded the law. It was in consequence of such intimation that C sought and obtained the interim anti-suit injunction. The tribunal made 2 clerical amendments but refused otherwise to amend the award. And then paragraph 18, which is at 1190. New York law, for the purpose of the argument, I'm also prepared to assume that D may be right in its contention as to the effect of New York law in relation to a challenge to the partial award. Thus, this was an issue which was hotly debated in extensive witness statement evidence. Sorry, that's the wrong reference. Sorry, forgive me. No, sorry. Yes, further down at just after letter H. The point about the proceedings that were being threatened in the US was that they covered a non-convention award. That was the point. So what was being threatened was a setting aside in the US because the award was not to be treated as a New York Convention award. So we get that just below letter H. Thus, notwithstanding the terms of Article 1.1 of the 1958 Convention, which provides that this convention shall apply to the recognition and enforcement of arbitral awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought, D submitted that the US Enabling Act limited the enactment of that article with the result that a foreign award arising out of a legal relationship entirely between citizens of the United States and without any reasonable relation with a foreign state was to be treated by the New York courts as a non-convention award. And then little 2, a non-convention award is governed by Chapter 1 of the Federal Arbitration Act, which permits a party to an arbitration to seek to confirm, modify, or vacate an arbitration award pursuant to sections 9 to 11 in any US court where venue is proper under the General Federal Venue Statute. Although not expressly stated in Chapter 1, a manifest disregard of New York law is by virtue of binding authority a ground for review. And then little 5, the partial award is a non-convention award in the eyes of the United States court because it arises out of a commercial legal relationship entirely between citizens of the US without a reasonable relation with a foreign state. So just to pull back and summarize, the judge is focused upon what the parties can only do in England, Section 67 and 68 setting aside. In this case, the losing party is threatened to go to the US and under a regime which is treating the award, which should be a New York Convention award, as a non-convention award, and applying for a vacator to get the award vacated for manifest disregard. And that was why an anti-suit injunction was entirely proper, because that was an erga omnes remedy being sought to actually nullify the award itself as an instrument, regardless of territory, outside of the New York Convention expressly. And importantly, if one then goes to 1202, the conclusion of the judgment, this is what the learned judge said. For the above reasons, it follows that C is entitled to the relief sought in the form of injunctions preventing a challenge to the award in any jurisdiction other than this court. These future intention has been made plain, and absent an injunction or continuing undertakings to this court to the same effect, D will launch proceedings in the Southern District of New York. There can therefore be no release from the undertakings given unless they are to be replaced by an injunction, and there can be no stay of the proceedings or any proceedings to enforce the partial award pending a decision of any foreign court on the validity of that partial award. Then he says this, none of this, of course, impacts upon any challenge D may be able to mount to enforcement in a foreign jurisdiction under Article 5 of the 1958 Convention on the grounds therein set out. He's expressly carved out New York Convention proceedings from C and D. That's not picked up on by Court of Appeal. It's not picked up on by my learned friends in their test. It shows that C versus D was never intended to bleed in my graphic from one side of the page to the other. It's not about New York Convention. That same dividing line was agreed by the claimant itself in the Court of Appeal in C versus D. If I can take you now to the Court of Appeal judgment, which starts at 1203. And if we can go to 1209. Just picking up from 1208, paragraph 9, the previous page, there's a heading, the parties' respective cases before the judge. And if you just then go over the page to 1209 from the top, first line, at the end, the only permissible challenges to the partial award itself were those which can be made under the 1996 Act, and the only permissible challenges to enforcement in other countries, which are parties to the 1958 Convention, as in the US, were those which arise under Article 5 of the Convention.
That's the case.
Yeah, that's their case.
No, but that's the argument at that point.
Yes.
You're quoting from the argument.
I'm quoting from the summary of what the position they put in asking for an anti-suit injunction. They were conceding. What they were saying was, if you're not within this...
So this is the claimant's case.
Correct.
So it's saying what they're asking for and what
That's what they're asking for.
it is. And
Yes.
And they, in their own submission...
In their own submission, they carve out New York Convention. And then, if I can take you to the operative, the paragraph which is the one which is always cited from the Court of Appeal, which is paragraph 16, that's 1210, under the heading Primary Conclusion. You will see that what was exercising the Court of Appeal was the overlap between vacator in America and Section 67 and 68 in England.
Sorry, which paragraph?
Paragraph 16.
16, yeah.
Yeah, page 1210.
Yes, thank you.
Lord Justice Longmore says, I shall deal with Mr. Hurst's arguments in due course, but in my judgment they fail to grapple with the central point at issue, which is whether or not, by choosing London as the seat of the arbitration, the parties must be taken to have agreed that proceedings on the award should be only those permitted by English law. In my view, they must be taken to have so agreed for the reasons given by the judge. And then just at letter H, Mr. Hurst could not say and did not say that English judicial remedies for lack of jurisdiction on procedural irregularities under Section 67 and 68 of the 1996 Act were not permitted. He was reduced to saying that New York judicial remedies were also permitted. And then 3 lines down, no doubt New York law has its own judicial remedies for want of jurisdiction and serious irregularity, but it could scarcely be supposed that a party aggrieved by one part of an award could proceed in one jurisdiction, and a party aggrieved by another part of an award could proceed in another jurisdiction. So what the court is concerned about, sorry, just going over the page, 1211 to paragraph 17, it follows from this that a choice of seat for the arbitration must be a choice of forum for remedies seeking to attack the award. As the judge said at 27, as a matter of construction of the insurance contract with its reference to English statutory law of arbitration, the parties incorporated the framework of the 1996 Act. He said that their agreement on the seat and the curial law necessarily meant that any challenges to any award had to be only those permitted by the 1996 Act.
So again, it's tying it to the construction of the contract, saying if you've chosen the London seat,
yes,
it's the panoply of things that you could, remedies available
correct,
to challenge in
but
London.
It's the panoply of remedies.
And that's it.
That's it. It's a panoply of remedies for attacking at the seat.
Yes.
The other side of the page is out of this.
No. Well, in the sense, there are two other sides of the page. One is what happens to recognition proceedings, and that's just left out of account for the reasons you've said. The other side of the page is where they're going to try and do in New York what they'd agreed could not be done.
Yes. But what he's saying is you agreed to London as a seat. You have contracted to only challenge the award for erga omnes style remedies, 67, 68, in London, nowhere else. But it's a totally different story about challenging recognition and enforcement. That's the point I'm making. And the Court of Appeal and my learned friend are using C&D to bring it across to the other side of the page and say any challenge would include challenges to recognition and enforcement under the New York Convention. And that has been expressly carved out. And again, without wanting to repeat what I've said, the minute you do that, you then destroy the architecture and double control, for all the reasons I've elaborated this morning.
So you either have to reduce what you mean by any
Yes.
or reduce what you mean by challenge.
Correct. And that's why I'd spent time this morning making the point that they are the same grounds, Article 34, Article 36 of the model law, Section 67, 68, Article 5 of the New York Convention. It's the same challenges, but for different purposes. That's why just using this mantra, any challenge, is not good enough.
Yeah, and different purposes, that really means with different relief in view.
Correct.
Yeah.
The case of Atlas, which was relied upon by the Court of Appeal, that is at 1132. A decision of Mr. Justice Phillips, as he then was. And if you go to paragraph 23, which is 1138, it says, on the 7th of July, sorry, just to pause again, it's the same configuration. London seated arbitration, attempt to set aside in Pakistan. Paragraph 23. On 7th of July 2017, NTDC also filed a claim in the court of the senior civil judge in Lahore, seeking an order declaring the partial award to be null and void and setting it aside. So that was only possible under the 1940 Arbitration Act in Pakistan.
Where do we see that the application was under that Act?
Yeah, that is, we've got the application itself.
Oh, yes.
So if I can take you to 505.
You don't pick it up from the report, is that right?
No, it will be. I think it's.
All right. Well, when you get to it,
yes.
it's fine.
I think you've made an application to put in the application.
Yes, exactly.
To show us the underlying basis for it, didn't you?
If you go to 505, that's the beginning of the application. If you look at the title of the plaint, this is the application in Pakistan to challenge the award. So the title of the plaint at 506 is Application under Section 30 of Arbitration Act 1940. You have that in page 506?
Yeah.
If you would then go to page 508, paragraph 35, it reads as follows. It's pertinent to point out that the IPPs, those are the independent power projects, have misrepresented the true facts even before the tribunal by similar presentation. As a matter of established Pakistani law, since all entities were Pakistani, the cause of action had arisen, and all the acts and actions, including but not limited to negotiation and mediation, were contemplated under laws of Pakistan at Lahore. Therefore, the ongoing arbitral proceedings were not the foreign arbitration, were not subject to Act 2011. Rather, even if related to arbitration agreement, would fall under Act 1940 in order to defend, etc. If you go to 513, you will see the relief that's sought, or the grounds of challenge at 513, paragraph 98. Grounds of challenge, the award is liable to be set aside for many legal and factual reasons, and then the grounds are there. It's not about resisting recognition and enforcement. It's a straightforward 1940 Act set aside. If you go to page 519, at the top, the end of what is the end of paragraph 147, the sentence, the tribunal miserably failed to appreciate that this being a local arbitration is subject to the Arbitration Act 1940.
Sorry, which paragraph on that page did you say?
It's paragraph 147, it's the end of that at the top.
147.
Yeah, so it's page one.
First sentence on the page.
Yes, page 519 of the bundle. I'm not sure the difference between failing to appreciate and miserably failing to appreciate, but in any event, that's what they did. And then at 522, you have the prayer, which is, if you look at the bottom of the page, further pray that the partial final award stated above be declared null and void ab initio. As a consequential relief, the same be set aside. So Atlas, like C&D, is a straightforward case for an anti-suit injunction, in my respectful submission, to protect the jurisdiction of the English court as the curial court. Because this, if you want it, you can only ask for it under the 1996 Act. But that is totally different to this case. And this is what the Court of Appeal just didn't really focus on. It's not a 1940 Act case. We're under the 2011 Act. I'm going to, in my remaining time, I will take you to the 2011 Act and the Supreme Court authority in Pakistan, which shows you cannot ask for this relief under that Act. It's only New York Convention. So, what I've now, I'm complete the first point on this, which is the other side say the case that we're advancing is contrary to C versus D. The answer is it's not at all. C versus D is not about New York Convention. It's about this kind of activity of setting aside. It's on that side of my graphic, that side of the page. Next point that is made against me is, well, some of these points I'm not going to elaborate because I think I've touched on them already and for sake of time. So they say at paragraph 30 of their written case, another reason why my test is wrong is because they question, or they say erga omnes doesn't apply because some enforcing courts will enforce an award that's already been set aside, and I've addressed you on that already.
That is the UKOS
Yes.
sort of situation.
Yes, that's the UKOS case, and for the reference 2639, and the other case I had mentioned is Malikor, and that's 2045. And I've then shown you the PT First Media in Singapore to show there's great doubt about anything beyond that. Next, they say at paragraph 31 of their written case that issue estoppel is a reason why this graphic and this test doesn't work, and I've addressed you on that already. And I will, for your reference, I have made a note about the travaux préparatoires being fatal for this argument anyway, and I can give you a reference to that, which is 3885. what you'll be looking at in that document is a Secretary General's summary of discussions dating from March 1958, UNCITRAL, a UN document. It predated UNCITRAL. United Nations Secretary General document, and it goes through a number of different models that were being addressed at the time, and the reference I've given to you in the Travo makes clear that it was not acceptable for a recognizing and enforcing court to be stuck with determinations that would be imposed upon it by other courts.
Just so I'm clear, these are the Travo for the UNCITRAL?
No, for the New York Convention.
Ah, right. Yes, I see. So it's looking forward to Articles 3 and 4 of the Convention.
Yes.
Yeah, okay.
Yes. Next, I want to address paragraph 32 of Malone and Friends' written case. Star Hydro say that the line that I have drawn and the erga omnes test falls down because they point to cases, there are 7 of them, where they say anti-suit injunctions have been granted based on a breach, even though it didn't involve challenges seeking relief that falls under section 67 to 69 of the 1996 Act. That sounded a bit incoherent as I said it. But it's paragraph 32 of my friend's written case.
Well, most of these seem to be about cases where people have tried to relitigate the issue that was decided in the arbitration.
That's the point. My Lord, I think perhaps...
But isn't that what you're doing, they say?
No, we're not. So what, and when I've completed this part, then I'll take you straight into the Lahore proceedings as to what we're asking for. And I've already said we are not seeking, we're not seeking to set aside the award. We're not seeking to say anything about the award as an instrument. The only thing we're seeking is we're questioning its effect, if any, in the territory of Pakistan.
Nor are you seeking to ask the Pakistan court, as I understand it, to decide the issues that the arbitrator decided, ignoring the award.
No,
it's all about what effect does the award have or not have in Pakistan.
That's it. That's the only point.
But that's the point they're interested in, isn't it? They want the money, they want the difference, they want the delta.
Yes.
So if you're attacking that, aren't you then attacking the outcome of the award?
We're not attacking the delta as a finding in an award. We are attacking its recognizability and enforceability in Pakistan. And that goes right back to the beginning as to the different nature of the remedies on each side of the page. So whatever we persuade, let's say we're successful, we may not be. If we're successful in Pakistan, that doesn't say anything about the award as an instrument.
Now, you're taking as I understand, you're taking the award as read, but saying you can't enforce it or not fully enforce it in Pakistan.
Correct.
In fact, there is still, you say, it's partially enforceable, but not.
Yes, and by the way, as we know from other cases, many entities have assets all over the world, and the award might be taken somewhere else. Who knows? But that's not for today. The only issue is and we're undertaking to make this clearer to the court if there's any doubt about it. The only thing we're seeking is whatever may or may not be available to us under the New York Convention in Pakistan.
I don't think it's been said against you here you're trying to relitigate the underlying issues, that the argument has been that you're trying to set aside the award even though you say you're not.
Yes. Yeah. So I won't then, I think, labour all these points, but the point is that the remedy that was being sought in each one of these cases, and I apologise for the term, was erga omnes. Each of these cases that are mentioned in this part of Malone and Friends' written case involves something which is akin to a setting aside. It's defeating the award. And one reference I'll just give you is the Sudha Vishni case, a judgment of Mr. Justice Foxton, as he then was, paragraph 78, page 2382. 2382. this case was actually about anti-arbitration injunctions, but he goes through different categories of challenges that may be made to an award. And in paragraph 78, he says, an alternative approach which I find strongly persuasive and which suffices for present purposes arises from the fact that there will be cases which fall both within category 1 and category 3. And then he says, because the attempt to relitigate the contents of the earlier award is sufficiently fundamental and substantial as to be fairly characterized as an attempt to challenge the earlier award by a non-compliant challenge. And by non-compliant challenge, he means a challenge not at the seat. So he's simply saying, of course, there will be times where if you go behind an award and try and relitigate, you're effectively trying to annul the award. And that's not limited to one territory. That's an attack on the instrument for all purposes, erga omnes. So, each of the cases the learned friend relies upon, Noble and Girling, that is paragraph 32A of his written case. You find that case at 2143 in the bundle. If you go to 2158...
Well, you may be going behind it, but there's a more straightforward reason, isn't there, that you've by agreeing to arbitrate, you've agreed not to litigate anyway.
Yes. And some of the cases have that as another ground. And actually some of these are also about vexation and oppression.
Okay.
Then I think perhaps, I'm not sure I need to go through each of these cases, but each one is looking for, it concerns an erga omnes or equivalent remedy. They're all attacking the award itself in different ways. And that goes all the way through to paragraph 36B of my learned friend's written case. So that is the architecture of the New York Convention and how it fits with the courts of the seat, and that is the concept of double control. And that now leads me to the next part of my submissions, which is to take you through what's happened in Lahore.
Yes.
And the award itself. Now, I need to give you just a bit of background on this. It's in the statement of facts, and it's in our written case. But I'm just going to summarize the factual background very briefly. Then I'm going to summarize what happened in the award, which is critical. And then I'll take you to what's happened in the proceedings now in Lahore. And that is, although it's a little bit of a journey, that is important to understand what we're asking for. So the beginning is electricity in Pakistan. It is a highly regulated area, as in many developing countries, and as with many areas, access to electricity is so important that there's actually Supreme Court authority in Pakistan which elevates it as part of the right to life in Article 9 of the Pakistan Constitution. The reference we have is a decision of the Supreme Court at 2864. So it is incredibly important in Pakistan law. Consistent with that importance, the pricing of electricity is highly regulated. And it is in the hands exclusively of one entity called NEPRA, N-E-P-R-A. NEPRA, by something called the NEPRA Act, has exclusive responsibility for regulating the provision of electricity, and that means determining tariffs, rates, charges, and any other conditions for supply of electricity.
And that's not just to consumers. It's not just a price regulation, the price that's charged to consumers, as I understand.
Not just consumers. Not just consumers, yeah.
No, so it regulates this B2B
yes.
contract,
Yes. And we've given, the NEPRA Act sets this out. I'm just giving you references, 3687, Section 7 of the NEPRA Act. Once NEPRA makes a decision on tariff, that is published in the official gazette in Pakistan. And at that point, it becomes part of Pakistan law. It's an important point. Can I take you to the award where that is stated, the arbitration award in question in this case? And that is at 445. At paragraph 376 to 377. So 376. While claimant alleges that there is nothing in the PPA preventing the sole arbitrator from departing from NEPRA's determination of 29th of July, it has not disputed the fact that as a result of its publication in the Gazette on the 2nd of August, this determination forms part of Pakistani law. 377. The sole arbitrator agrees with respondent that NEPRA's determination of 29th July 2020 is now part of Pakistani law, and that this is a reality regardless of whether any such determination was required by the PPA or by law.
And the PPA
is the power purchase agreement.
Oh, yes, okay.
And that's where the arbitration agreement is in the PPA. I should just to help you through the facts, just let me step back and just give you the context. This is a fight over tariff. Tariff is set by NEPRA. Only NEPRA can set tariff. The other side of the power producer, disagrees with a tariff that NEPRA has set, says that there's a contractual formula which actually gives you the tariff under the PPA, starts an arbitration and asks the arbitrator to calculate the tariff, essentially, by applying a contractual formula.
Well, whether the arbitrator was right or wrong in his analysis of the relationship between the statutory and contractual regimes is neither here nor there, as far as we're concerned, is it?
No, but it's very important to understand the remedy that he gave and what we're asking for enforcement of.
All right.
It's very important for that. So that's I've just given you the broad measure. So it's accepted that the minute that NEPRA sets a tariff and it's published in the official gazette, it becomes Pakistani law. And that means an application to the arbitrator for a contractual tariff has got to reckon with the fact that Pakistani law might be inconsistent, because NEPRA has set a tariff. That's the point.
When you say it becomes Pakistani law,
Yeah.
it then becomes illegal for Star Hydro to charge National Transmission any price per kilowatt hour other than the price set by NEPRA.
And not possible for my client to pay for it at that price.
Because that also would be unlawful.
Yes. That's the problem where we get into public policy and non-arbitrability. That's why I'm painting this picture for you, to understand what the issue here is, not asking whether it's right or wrong. This is just how the facts sit. There is Pakistan law in cases which are in the bundle showing that nobody else apart from NEPRA can set a tariff. And you'll see cases at 2837, 2911. You'll see, I'll give you references to that. So it was my client's case throughout that as a consequence of this exclusivity that NEPRA had, a dispute requiring calculation of tariff wasn't arbitrable, and it wouldn't be recognized or enforceable in Pakistan if this contractual arbitrator is going to set a tariff. There was a previous example of this already. There was a previous case before the Lahore High Court involving the same contract and the same parties, where a previous arbitrator made a ruling that impacted on the tariff that was payable. And the Lahore High Court refused to recognize and enforce that part of the award on the basis it was not arbitrable and contrary to public policy. And the reference to that is 2933. This is a judgment of the Lahore High Court between the same parties, Justice Shahid Karim. And if I can ask you to go, please, to 2937. This is paragraph 6 of the judgment, and just picking up about 10, 8 or 10 lines down, there's a sentence beginning, the issue regarding debt servicing. Actually, I should just explain what the point was. I'll just explain it, it's simpler. In this previous dispute, a previous arbitrator had held that contractual delay damages were payable. What were called principal debt damages, they were payable between the parties, despite the fact that those damages had already been incorporated into a tariff that NEPRA had determined, which would be recoverable through the life of the project. So NEPRA had determined a tariff. It had included and taken account of these principal debt damages, but the arbitrator went ahead and ordered anyway to say that these are payable. So there was a potential problem of double recovery. But more importantly, what the arbitrator had done was to make an order which would assume that NEPRA would make the correction to avoid double recovery. And that impacted on NEPRA's authority, because it's only up to NEPRA to decide whether it does it or doesn't do it. And because of that, that element was held by the Lahore High Court as not arbitrable, contrary to public policy, not recognisable and enforceable under the 2011 Act. And we see that then just in the wording here. If I can take you back to 2937. Judge said the issue regarding debt servicing component can be found in the decision of NEPRA at clause 6.5. The sole arbitrator went on to hold that the payment of principal debt damages will not be contingent upon or related to any subsequent decision of NEPRA relating to tariff. This would in fact be putting the applicant in an advantageous position as against NTDC, fails to consider the ultimate decision which may be made by NEPRA. That decision could also deny the application made by the applicant herein, and so the applicant would be unjustly enriched by that payment being made part of the award and also granted by NEPRA in its decision. Thus, the award of the sole proprietor to this extent is unsustainable and cannot be enforced, since this aspect was always within contemplation of the laws of Pakistan and stood determined through a decision of NEPRA. No claim could be brought by the applicant regarding this amount before the sole arbitrator at LCIA. The recognition and enforcement of the award to the extent of this amount is denied. So it's partial recognition and enforcement by the Pakistan High Court and non-recognition because of the area that intruded on the discretion of NEPRA. It is said now by Star Hydro that this decision is not about arbitrability or public policy, it's just about double recovery. That is not so for two reasons. Firstly, double recovery is not a ground under Article 5 of the New York Convention to resist recognition and enforcement. And secondly, because we have Star Hydro's own appeal against this decision on record, and that you will find at 4641, and the appeal explains to the Supreme Court in Pakistan that this is an incorrect decision on arbitrability and public policy. I don't know if you want me to go into that level of detail at this point, but
I think probably not necessary.
Yeah. So here are the facts. Star Hydro understood this regulatory environment well. Consistently with this regime in this project, it did request and obtain tariff determinations from NEPRA at each stage of the project. So it has engaged NEPRA all the way through. But there was an about face that happened after the COD tariff date, the final stage, the commissioning.
So we're moving now to our case.
Yeah. No, we're back in our case.
No,
sorry, forgive me, I'm going quite fast.
Yeah, no.
I just wanted to show you this document,
Right,
to show you
okay.
non-arbitrability, partial recognition and enforcement between these parties, and the centrality of NEPRA, exclusivity of NEPRA. Now, I've finished on this case, and now I'm back in our case.
Yes, that's what I thought.
So the other side engaged with NEPRA all the way through until a moment where NEPRA gave a tariff that they disagreed with. At COD, that's the commissioning stage. And at that point, they said they didn't agree with NEPRA's tariff, so they then went back to the power purchase agreement and asked an arbitrator appointed under that to apply the contractual remedy in the contract to set how much was due for the tariff. And what's important is to look at the relief that they sought from the arbitral tribunal. And that we get from the award. If I can ask you to go, please, to 417. Is paragraph 234 of the award, where Star Hydro's position is summarized. It says, Star Hydro's primary position is that NTDC has breached the PPA by failing to agree to the mechanism for adjustment of the COD tariff set out in Schedule 1 of the PPA, and or failing to make payments in accordance with that adjustment. But for this breach, Star Hydro submits that it would be receiving the tariff payments to which it is entitled, which reflect the costs it invested into the project. It therefore claims that it is entitled to a declaration of the tariff at COD in accordance with Schedule 1, as well as contractual damages in the form of payment of the balance between the tariff payments to which it claims it's entitled and those it has actually received from NTDC to date with interest. And then if you go back to paragraph 75 of the award, that's at page 382, you will see the relief is set out, is quoted at paragraph 75. And that you'll see that the claimant respectfully requests the sole arbitrator to, so firstly, declare that pursuant to Schedule 1 of the PPA, the adjusted project cost at COD is, that's a contractual formula. And then 2, declare that SHPL is entitled, pursuant to Schedule 1 of the PPA, to a COD tariff of 10.6. So that's a declaration of entitlement to a COD tariff. And then 3 is an order to pay the balance of the COD tariff to the extent not compensated by the tariff paid by NTDC up to the date of the award. That's the delta, the difference between the two. I'm emphasizing this because this was not, this declaration at 2 was not awarded by the sole arbitrator. Something different was awarded in the end. And I'm going to show you that. So if we go to the award is May 2024. Well, we're in this at the moment.
We're in the award.
Yeah, we're in the award. Helps us. In terms of jurisdiction, the tribunal confirmed that NEPRO had the sole authority to set electricity tariffs as a matter of Pakistan law. For your reference, that's paragraphs 126 to 127 of the award, page 395 of the bundle. But the sole arbitrator considered that he could still opine on matters of contractual interpretation. So even though we've got this idea of exclusive authority with NEPRA, NEPRA sets the tariff which is Pakistan law and binding. Somehow between that, the tribunal says, but I can still rule on contract between these parties and make a contractual declaration. So immediately we've got two things which are in competition. Some sort of contractual determination, and then the regulatory situation which applies as a matter of Pakistan law. And that's the key to this. So can I take you now, please, to page 400. And paragraph 150. The tribunal said, in any event, so just to preface this, NTDC is complaining all the way, saying you can't make these contractual determinations because they impact on the regulatory side, and that's not arbitrable as contrary to public policy, because you're treading on NEPRA's authority. And Star Hydro say, no, don't worry about that, it's just contract. That's a separate regulatory side. As a matter of contract, you can proceed. So paragraph 150 is how the tribunal starts to reconcile these two points. 150, in any event, notwithstanding NTDC's public-facing role, it's still a commercial entity which has voluntarily entered into a commercial contract and cannot escape the implications of the terms it has agreed to. If that means that money is owed to Star Hydro, then that sum is due as a matter of contract. The fact that such an order may also have indirect implications for consumers is a natural and unavoidable consequence of NTDC's role, and as pointed out by Claimants' Counsel in closing submissions, Any time any government entity anywhere in the world enters into a commercial contract, its commercial capacity, it's spending taxpayer money, that's no reason not to hold the government department to the contract it decided to sign. There's in any event no legal or regulatory barrier to an order that Star Hydro is entitled to what it claims the balance for the past if it is determined that anything is due as a matter of contract. So just pausing there, they're saying, look, for contract damages, there's no legal or regulatory barrier. Then carrying on at 151, it therefore follows that whilst the sole arbitrator has the authority to opine on matters of contractual interpretation, in the event that it is determined that a correct application of the PPA would in theory lead to a different tariff than that which was published in the Gazette, the parties would need to address this misalignment amongst themselves going forward. And then 152. With respect to claimants' requested relief for the past, however, a declaration as to the theoretical consequences of the application of the PPA would serve a practical purpose. If it is established that the application of the PPA would in theory result in a different tariff than that arrived at by NEPRA, it is within the powers of the sole arbitrator to order payment of the delta between the amount which should have been paid and what has actually been paid to date. Since that is a purely contractual matter, and there's nothing in Pakistani law which would prevent such an order, the fact that such an order may have indirect implications for consumers as stated above, natural and unavoidable consequence. We then get to paragraph 371 to 376, and then 377, where all this is pulled together by the tribunal. He's got these competing ideas of Pakistani law, what is the regulatory position, and then what can he do by contract. If I can take you to 445. Starting from, so there's a heading, NEPRA's COD determination, tariff determination of July 2020, paragraph 371. As has already been established, the parties are in agreement that only NEPRA can determine and approve the tariff for electricity in Pakistan. This is also the clear position under Pakistani law. 372. Rather, the dispute centres on whether the sole arbitrator can declare that the application of the adjustment mechanism set out in Schedule 1 of the PPA leads to a different calculation of the project costs and COD tariff than that found by NEPRA in its determination, and whether such a declaration amounts to a departure from NEPRA's determination. 373. It has already been established that on a purely contractual level, there's no barrier to an arbitral tribunal opining on provisions set out in a commercial contract which contains an arbitration clause, and issuing decisions as to the interpretation and application of that contract, and that the sole arbitrator must determine questions of contractual interpretation and application arising out of this specific contract. To this extent, the sole arbitrator is not prevented from reaching a different conclusion as to the consequences of the application of Schedule 1 of the PPA than the conclusion reached by NEPRA. This is notwithstanding the fact that NEPRA's tariff, published in the Gazette on 2nd August 21, provides that Star Hydro is allowed to charge tariff of rupees 8.3924. As stated previously, the fact that this tariff is published in the Gazette does not necessarily mean that it arose from a correct application of the contract. As far as contractual interpretation is concerned, then the sole arbitrator can depart from NEPRA's interpretation of the PPA. 374, the question which then arises is this: what are the implications of issuing a declaration that the tariff which results from the application of Schedule 1 is different from that declared by NEPRA? And members of the court, this is absolutely critical to what we're seeking in Pakistan now. 375, in Respondent's view, any declaration departing from NEPRA's determination would cause the parties to violate the laws of Pakistan. And the Respondent is us. 376, while claimant alleges that there is nothing in the PPA preventing the sole arbitrator from departing from NEPRA's determination of 29th July 2020, it has not disputed the fact that as a result of its publication in the Gazette, this determination forms part of Pakistani law. And then the critical paragraph 377. The sole arbitrator agrees with Respondent, that's us, that NEPRA's determination of 29th of July is now part of Pakistan law, and that this is a reality regardless of whether any such determination was required by the PPA or by law. The fact that NEPRA may have incorrectly applied the contract is one thing. The fact remains that this tariff, even if it can be proven to be contractually wrong, has been published in the Gazette. Accordingly, any declaration from the sole arbitrator on the tariff resulting from a correct application of Schedule 1 could not replace the tariff set by NEPRA going forward. The most that such a declaration could achieve with respect to the current and future tariff would be to identify a misalignment between the law and the contract on the basis of which the parties can work together with the relevant authorities to remedy the misalignment going forward. So what he's doing is, he's saying, I can, because of Pakistan law, as a matter of contract, I can tell you what the contract means as a sole arbitrator under the contract. That may allow you to raise a delta for past damages where there's a difference. Going forward for the current and future tariff, my declaration, the most it can be used for, because of Pakistani law, is it's a weapon for you to try and negotiate with NEPRA to correct this misalignment. That's all. Because otherwise it's Pakistani law, the tariff.
But presumably as you go forward, there becomes then new delta.
Yes, correct.
So you can...
Yes.
You can keep going.
Now, my lady is completely right, and all I can do is explain what the sole arbitrator's logic is, which is presumably then, as that keeps going, you have another arbitration up to that date of arbitration for the delta that's built up. I mean, it's not obvious, but anyway, that's whether it's right or wrong. That's what he ordered. So he's got these two tracks. The tariff, can't change that, it's Pakistani law. Can't touch NEPRA. A delta is creeping up because of contractual interpretation, which may have to be paid. My client's case is that doesn't work. Even the contractual damages building up, in effect, is asking us to pay a tariff different from, in effect, a tariff different from NEPRA. And therefore, going back to the judgment I showed you in the other case, our position is that's not arbitrable or it's contrary to public policy, because you're undermining NEPRA with this contractual thing.
Now, Mr. Landau, you've got 5 minutes left of your allotted time, I think.
I had...
Oh, sorry, when...
You gave...
To 3:25? Yeah, to 3:24.
I thought until 4.
Oh, are you to 4? Oh, sorry, forgive me, I'm being really stupid. Forgive me. I've become, yes, mystified by stenographers and appellants. Forgive me. Forget I said anything at all.
A moment to recover from my minor card.
Quite right, sorry.
So what he's saying in turn...
I mean, you may or may not be prepared or able to answer, why didn't you challenge the award in this?
We didn't need to, because we have a choice of remedies. So any party is this is Dalla in terms as stated, we have a right to either challenge at the seat or to resist recognition and enforcement in wherever recognition and enforcement is sought. And that's part of the double control. And that's all the paragraphs I showed you in Dalla saying you can't be criticised, because Dalla was a case of recognition and enforcement in this country where...
No, I understand your answer.
Yeah. Forgive me, I know I'm reading a lot, but I just want to follow through the paragraphs, just the following ones here, because the distinction here again is drawn between a declaration of tariff and this contractual animal that's happening in parallel. So 378, with respect to the past, however, a declaration as to the consequences of the application of the PPA would serve a practical purpose for the claimant, as it would give rise to a contractual claim for the delta between the amount which should have been paid and what has actually been paid to date. Notwithstanding NTDC's public-facing role, it's still a commercial entity, and I won't read all of this because this is the same as we had seen in earlier paragraphs. 379, the fact that such an order may also have indirect implications for consumers is a natural, unavoidable consequence. And then 380, unlike determining the tariff then, there is no legal or regulatory barrier to an order that Star Hydro is entitled to what it calls the balance for the past if it's determined that anything is due as a matter of contract. So I'm stopping reading there.
Well, I think the arbitrator said this several times over by now, hasn't he?
Yeah.
Yeah.
So he's got one point, but he makes it over many pages.
But it's vital, because if you remember the relief that was claimed by Star Hydro, I showed you at paragraph 75 of the award, that they are entitled to a COD tariff. If you take that and compare it to what was actually ordered in the dispositive, they didn't get it. So if you go, please, to 474.
I mean, you're not disputing that this seems a very strange way to articulate and reason through what's going on. You might say, surely you've either got a contractual damages claim that is valid, or you haven't,
Yes.
on the grounds that it's illegal or contrary to public policy. And this
Right.
attempt to drive two possibilities is not, at the moment, striking me as particularly rational or logical. But this is not what we're here to decide.
Not what you're here to decide. So, and the only reason I'm doing this, I know it's a painful task at this time of day, but the only reason I'm doing this is because it's vital to explain what we're asking for in Pakistan.
Yes.
So, perhaps I'm sorry to do this, can I just remind you of the wording of paragraph 75 of the award first? If you go to 382 first, and remind yourself what was actually requested by Star Hydro. And then compare that to what was actually ordered in a dispositive, and it's different. So what was actually ordered is at 474. And 474, the paragraph is 514. So A is declaring that he has jurisdiction, although we said that this is not arbitrable. B declares the claims are admissible. Then this is the formulation that the arbitrator comes up with. Declares that the correct application of Schedule 1 of the PPA results in a final project cost of 378 and a COD tariff of 10.36. The language entitled to that tariff has gone, because all that the tribunal is doing now is making a contractual declaration of what would be the logic of it. But going back to 377 of the award, which I just showed you, he has ruled that the only use that can be made of that declaration, apart from claiming a historic delta, is to use it in negotiations with NEPRA to try and change NEPRA's tariff. That's the only use. And then if you go down to the last paragraph of the dispositive, it dismisses and denies all other claims and requests for relief. So that claim, insofar as it was an entitlement to a tariff, has been dismissed. Now that is why we say we are entitled to recognition, partial recognition and enforcement of that dismissal in the last part of the dispositive. This was a major victory for my client. In partial victory. Partial.
A major partial victory.
A major partial victory. And it's significant also because, bear in mind, this is one of hundreds of PPAs, so this doesn't affect just this client, it affects all sorts of people. What the major partial...
Oh, I see. What the electricity that's generated from this plant
Yeah.
is sold to lots of different...
There are many, many PPAs in Pakistan, and they all have the same contract. And so the problem, the big issue for Pakistan is that if this award is right and it's enforced in the way that Star is thinking that it can be enforced, so they've never asked to enforce it in Pakistan, they've never made the application, that could impact on the construction of this contract for all the PPAs. So all the PPAs could suddenly think NEPRA is fine, but we can have a separate contractual route as well. And that, of course, would be devastating. But anyway, so can I go back to my major partial victory? Where we had said all the way along that you can't change NEPRA's tariff. What the arbitrator did do was to say in 377, I can give a declaration. But the most you can do with that is try and get NEPRA to change the...
Because the PPA is also approved by NEPRA.
Yes, it is, and that was their position. Their argument is, look, if the NEPRA has approved the PPA, they've exhausted their mandate. So there's nothing to go back to them on. And we disagree with that. But that was the reason why their justification. Yes. Now, just very quickly, and I know my time is running, although I do have a bit more time. What happened?
So you're essentially saying that this is a favourable decision in your...
Not completely. No. But there's
as far,
part
as
of
far
it.
as the dispositive.
Well, part of it is favourable, which is the last bit, which is says it's denying what was actually...
Dismissing all the other...
It's dismissing the entitlement.
And that's essentially what you're trying to have.
That's what we want affirmatively enforced.
But you don't want to enforce the fact that you have to pay the
Correct.
damages. So
Correct.
you want partial recognition
Yes.
and partial
Correct.
non-recognition.
Correct. And because we say that the rest of it, the contract part, bearing in mind the previous decision of the Law High Court I showed you, the rest of it we say is not arbitrable and contrary to public policy, because this idea of some separate contractual entitlement divorced from NEPRA is contrary to Pakistan law. And in the end, if we have to pay even past damages, we're going to be forced to act contrary to Pakistan law, even if you call it contractual damages. So that's our position, and that's what we're putting forward to the Lahore court. But that is all about the treatment of this award in Pakistan. And why are we concerned with that? Let me just explain. We, after this award, have been placed in an impossible position in Pakistan, because Star Hydro, the first thing they did was to start issuing invoices to us for tariff, COD tariff, premised upon these figures. We've got them in...
past or as you...
No, current and future. So as we're going forward now, they are issuing invoices, which presumably they'll do for the next 30 years, or until the 30-year period of the duration of the project is over, for tariff, COD tariff, at this 10.3632 figure. And we've got them in the bundle. You can look, for example, as an example, 623. I won't turn it up, but 623 is one of the invoices. It's a request 4th of June 2024 for capacity payment premised upon the tribunal's declaration. Now, we say you can't do that because the tribunal has ruled in 377 that the most that you can use the declaration for is to negotiate with NEPRA. They, of course, have not taken this award to the Pakistan Court for recognition and enforcement under the New York Convention. Why have they not? We can speculate. But we know the previous decision of the Law High Court, which said any intrusion on NEPRA is not arbitrable, contrary to public policy. So they don't do that, but they keep issuing invoices. So at that point, we are placed in a very difficult position in terms of our obligations. So the step that was taken, which in my respectful submission is perfectly understandable, is to ask the Pakistan court for partial recognition of that dismissal of the claims, which links to 377 and the findings which are identified in the Lahore plaint that NEPRA has exclusivity, only NEPRA can set the tariff, and that a declaration cannot be used as a basis for a tariff invoice, can only be used to negotiate with NEPRA.
You're also, and I'm not saying you shouldn't be doing this, but effectively, aren't you asking for non-recognition
Yes, we are.
of the, the other half?
Yes, we are. Yeah. And the other half, we are asking for non-recognition, and basically our primary position is we're only asking for this part to be partially recognised and enforced. And the logic of that, as we've set out, is we're not asking for the rest because we say the rest is not recognisable and enforceable because it's contrary to public policy and arbitrability. And can I just...
I think you're saying it's relevant that we understand that you're asking for part to be enforced, but it shows that the nature of your proceedings in Pakistan are not to annul,
Correct.
seek to annul
Correct.
The whole award.
Correct. I mean,
The bit that you're asking for non-recognition of includes the invoicing for the past delta.
Yes. And can I just go back to recall the structure of Article 5 of the New York Convention? I told you there are two groups of defences. We're under 5.2, not 5.1. And 5.2 is what the court is entitled to raise ex officio, sua sponte, or any other Latin equivalent. It can raise it itself
Follow that for the public policy bit, but the non-arbitrary...
Same.
That's the same.
Same.
Also under 5.
That's the first limb of 5.
First limb.
Oh, is it? Sorry.
First limb. And arbitrability is generally considered a public policy consideration. In fact, if you look at the Travo, it's only because of historic reasons to do with the Geneva Convention that arbitrability has been separated from public policy, because actually it is public policy. It's what a particular state will allow to be arbitrated.
Thank you very much.
So these grounds upon which we say that the rest of the dispositive are not recognisable and enforceable we can invite the court to raise it, look at it themselves. I mean, it's something that's in their gift. The fact that we do that should not be a breach of the arbitration agreement. It's simply an implementation of Article 5 of the New York Convention. We could put it affirmatively to the Pakistan court and say, number one, we apply for recognition and enforcement of part of it. Number two, we apply for a declaration of non-recognition and non-enforceability. And that's the German, what happens in Germany. And we've put in our submissions, it happens in many other countries as well. There's an open question whether we can do that in Pakistan. Let the Pakistan court decide that. But equally, there's nothing wrong for us to say we're asking for partial recognition and enforcement of this bit, because we want them to stop invoicing us. And we invite the court under 5.2 ex officio to consider whether the rest of it contravenes public policy or arbitrability. That's up to the court. Throughout this, we are not asking for set-aside. We are not asking for an annulment of this award. And I have to take you then to the Lahore application itself to make that good. The Lahore application is at 495. Sorry, that's the prayer for relief. 475, thank you. It begins at 475. And this is where I need to take you to the 2011 Act. Because the point that I keep making is, under the 2011 Act, we couldn't ask for set-aside. So if you look at the heading at 475, it's under the 2011 Act, which is the New York Convention implementation. The 2011 Act is at 3667, and I'd like to take you to 3669, which is the relevant section. Section 6, if you have that, enforcement of foreign arbitral award, unless the court, pursuant to Section 7, refuses the application seeking recognition and enforcement of a foreign arbitral award, the court shall recognise and enforce the award in the same manner as a judgment or order of a court in Pakistan. And then paragraph 7, unenforceable foreign arbitral awards, the recognition and enforcement of a foreign arbitral award shall not be refused except in accordance with Article 5 of the New York Convention. This is standard New York Convention language. This is not the Atlas case, it's not the 1940 Act. And Pakistan's Supreme Court has laid down in absolute clear terms the limits of the 2011 Act. I mean, it's clear on the face of the Act because the Act has got no provision in it on setting aside. It's got nothing akin to Section 67 or 68 of our Act. It's simply New York Convention. The leading case in Pakistan is Taysai Corporation. That is at 2939. And this is a frequently cited case now in Pakistan because Pakistan is going through a period of trying to upgrade its arbitration law, which it is doing through a number of important decisions. And this is a leading decision now to clarify that the old days of the 1940 Act are over for international cases. Can I take you please to 2955?
Sorry, can you just remind me, the 1940 Act,
Yeah.
how was that different from the 2011?
Right, so 1940
general
Act
terms.
is a gift that we gave throughout the Commonwealth,
Yeah.
and it comes from the 1934 Act, which was itself based upon the 1889 Act. It is an ancient arbitration act, and it covers all of arbitration law, like our 1996 Act, and it allows you to apply to the court to set aside an award for misconduct by a tribunal of the proceedings, which is a very broad concept. So the 1940 Act has been still good law in Pakistan, is the basis upon which you try and set aside awards. And that covers the ground of our Section 67, 68, and 69.
Right, so that stays in force.
And that's domestic, just domestic. For domestic arbitration, it's still in force.
And it's not in force for foreign
No,
arbitration awards.
2011 now is New York
Has replaced
Convention
The argument in Atlas Power was that it really was a domestic arbitration, as I understood it, and therefore they could invoke that act.
Yes, exactly. Sorry, I think I've given a very complex answer to.
No, I've got it. It's fine.
So
Thank you.
1940 Act
It's
is.
a bit like C and D, that,
Yes.
that they had some kind of local law that
Correct.
said if it's just between two people in this jurisdiction, it's
Correct.
ours, and never mind what
That's
you've
it.
agreed. Yeah.
And then you could just try and set it aside on any grounds, and that was the problem. So 2011 is the big change, because that's when Pakistan implemented for the first time the New York Convention into Pakistan law. There were some ordinances before, for the years before, and then the first act of the National Assembly was 2011, which implemented the New York Convention for foreign arbitration. And that's a totally different regime now. It's just New York Convention. If I can ask you to go to 2955, paragraph 34 of the Pakistan Supreme Court. Because I'm short of time, can I just give you the paragraph references, perhaps? Paragraph 34, 38, and 41. And what the Supreme Court lays down is the fact that what they call the maximum level of control, which is an expression that's used throughout New York Convention contracting states, the maximum level of control that can be exercised is Article 5 of the New York Convention. That wording you will see at, if I can find it. It's in the judgment.
It's in 38.
Yes,
bottom
that's
page,
it. That's it. Thank you.
2956.
Thank you very much. And that's critical. So we can't ask the court for anything more than Article 5. Again, Court of Appeal missed that point. That takes us to the relief we're actually seeking. And if you look at it at 495, it is premised upon the findings that I have, all of it's premised upon the findings that I have shown you in the award. If you look at A, this court may kindly pass a judgment and order to recognize and enforce the award in terms of paragraph 30 hereof. Now, if you go back to paragraph 30 of this document, that sets out, it lists findings that I have shown you in the award. But then it says, and in particular, 514I of the award. And that's the one I showed you, the last one in the dispositive.
Further relief? Or?
Yeah, it's the one saying all other...
Relief is it's
the one that dismisses all the claims.
Yes.
And that dismisses the entitlement. That's the hook in the dispositive for the fact that the entitlement to a tariff was not ordered. By holding that, the little one, only NEPRA has the power to determine, approve, or alter tariff for electric power services under the laws of Pakistan, including in respect of import of electricity generated by a project located in Azad, Jammu Kashmir, and post-COD indexations and COD tariff being part of Pakistani law applies to the project unless altered by NEPRA. So that is a statement simply of the exclusivity of NEPRA, and then consequently, the assumption of jurisdiction by the sole arbitrator vis-à-vis contractual assessment of the project cost and tariff at COD is a nullity in the eyes of the law, and accordingly, paragraphs 514A to 514H are neither recognizable nor enforceable under the 2011 Act. Now, this is going back to my Lord Borough's question, I think, about nullification. It's unfair to stop at nullity here, because there's no prayer in this document for setting aside. It is a nullity in the eyes of the law, and accordingly, and this is what's being asked for, paragraphs 514A to H are neither recognizable nor enforceable under the 2011 Act. So that's a New York Convention application. Why are they not recognizable and not enforceable? Because they're a nullity as a matter of Pakistan law. That's about arbitrability and public policy. That's not setting aside. And that was a mistake in my respectful submission to the Court of Appeal, simply saying, well, nullity means you're doing what was being asked for in C and D. But we're not, and we can't. We simply can't as a matter of Pakistan law. And whether we can or can't, and whether this is right or wrong, must be a question for the Pakistan court, not the English court. Prayer B, subject to A, above, and in the alternative, this court may kindly pass a judgment and order by declaring that in terms of paragraph 35(2) above, no amounts are payable by the applicant to respondent number 1 pursuant to paragraph 514D of the award. This has been explained in our submissions, and it's been explained in detail to the Pakistan court in further submissions, which are on the record. This is an alternative application for full recognition and enforcement, but with quantification. So it says in the alternative, which is an alternative to A, this is that a judgment may be passed recognizing and enforcing the whole award, but quantifying what that delta is. Because it's my client's case that the delta actually is nil, because the formula, when you apply it, the formula that the tribunal ordered, means there isn't a differential, as we had paid a certain amount up to that date. Many awards are not quantified, they just have a formula. And so it will be for the recognizing and enforcing court to apply the formula.
So, sorry, are you saying that even on its own terms, the arbitrator was wrong to say that there was a delta of a substantial amount?
Well, he didn't say whether there was a delta or not. He said there would be an obligation to pay the delta, but it had to be calculated.
Yes, but if he sets a kilowatt hour rate at a higher rate than you've been paying, then there must be a delta.
Yes, but that assumes there is a differential. And my client's case is no, because of indexation and various other factors. In fact, we haven't paid below that. And that's just on the facts.
So you've been paying at a rate higher
Correct.
than the
So there's no delta.
contractual rate.
Right. And that has to be worked out. But the other side are not going to the court for recognition and enforcement. They're simply issuing invoices. And so what we want is for this to be dealt with, and that's the natural place to deal with it, is the court of recognition and enforcement, where that would be an issue to be resolved, because that's part of the recognition and enforcement. And then C, respondent number 1, be permanently restrained from taking any action, including issuance and processing of invoices under the PPA, and commencement of any proceedings directly or indirectly, recognizing or enforcing a tariff that is different in any way to the COD stage tariff as determined by NEPRA for the project, or in the contrary, alternative, contrary to the express findings of the award, as set out in paragraph 35(2) of this application. That's just part of enforcement of paragraph 377. What it's simply saying is an injunction to stop them from doing what they're not supposed to be doing in 377 in Pakistan, and we can clarify if it's needed. Nowhere else. We're not saying anything about anywhere else. But this is about recognizing and enforcing a tariff different to the COD stage tariff. Because they won't go to court to ask for recognition and enforcement, but they keep sending us invoices.
And is it in recognition also of paragraph 514(1)?
Yes, absolutely.
Both.
Absolutely. Absolutely. Because that's where the tribunal didn't give them the entitlement which they wanted. And if they had in the dispositive had an entitlement to that COD tariff, and if 377 wasn't there saying this declaration can't be used for that, then fair enough. We have now given a series of alternatives to whittle this down.
The most important seems to be probably that in C it should say from taking any action in Pakistan.
Yes. Yes.
Because presumably, like here, if you have the person within the jurisdiction, you can injunct them from doing anything anywhere in the world. So that's what it looks like.
Yes, and if that needs to be clarified, then that we're undertaking to do that. Yes. So what we have put together on one piece of double-sided, one piece of paper.
Right, can I just check that that is one of the undertakings that you've given?
Yes.
Yeah, I think it's in all of them.
It is. 94.
About 92. Oh yes, included territorial limitation
Yes.
in respect to the injunction.
Yes, absolutely.
That's what that is.
Absolutely. So, in our series of alternatives. We've set out how we can whittle this down to give more comfort, any comfort that's needed, to show that all we're doing is New York Convention, because that's all we can do under the 2011 Act. We've put together a double-sided sheet of paper which sets out the relief with track changes under each alternative to show what it looks like on the basis of our undertakings. If it's helpful, could I?
Yes, I think so. Yes, thank you. That would be helpful.
My lead friend has it. Thank you so much. Thank you. They have it. Thank you. I think it's self-explanatory on the basis of the way we've described the undertakings.
So this is in replacement for what's at page 495.
Correct. I've been asked just to clarify that Star Hydro have stopped invoicing us once we commenced these 4 proceedings, but there's a risk that they may start again. So when I said that they keep invoicing us, I've been asked just to clarify. When we did start these proceedings in Lahore, which are now enjoined by the English court, they stopped invoicing. But of course, there's nothing to say they won't start again. My lady, my lords, where that takes me to.
And sorry, are these in a priority? Is this a priority?
Yes, it's a cascade.
Right. So your primary one case is alternative 1.
Right. It follows that.
Yeah. Okay.
Yes, and it's in the heading, each one, it says paragraph, written case paragraph 94, written case paragraph 95. There are 3 alternatives, and written case paragraph 96.
So these are partially, I did ask you before whether the undertakings offered were unconditional. I mean, as I now understand it, they are partially contingent on us having concerns that would be met by a particular thing.
Yeah.
And we phrased it that way in our written case. We've said insofar as there is a concern that, and then we give an alternative, and we say insofar as there's a further concern or the court is still concerned, then we give another alternative.
But your primary case, as I understand it, is you say, if we make the modifications at paragraph 94 of your case, alternative 1 here, that actually is sufficient.
Yes.
And we should be allowed to proceed in Pakistan seeking those matters as prayer.
Yes. And I think you also say that's what we always meant, albeit it was rather unfortunately phrased at 495.
Yes.
So you're not conceding that you are restricting the nature of the relief that you at any time sought from the Lahore.
That is correct. And that's correct because...
Because it's under the 2011 Act, not the 1940
Act. My calculation is I have 7 minutes left. Can I just say where I've got to in the course of submissions? I've now...
What it's worth, 9 minutes by my adjusting calculation.
I don't
for arguing about the minutes, it's like...
I don't know if the Supreme Court
I caused you a near heart attack.
I know what I was going to say. I don't know what the rules are for injury time. But I had, which may seem like a long time ago, when I charted out my intended course, I said I'd start with issues 1, 1A and B, and that's what I've now covered. So I've made submissions after my lengthy overview. I made submissions on the test that has to be applied. I've made submissions on what has happened in Pakistan and what we're asking for and why. The conclusion from all of that, in my respectful submission, is that the Court of Appeal was plainly wrong, that this is not a C&D case, that this is a case where we have not breached the arbitration agreement by commencing New York Convention proceedings in Lahore. And that means, going back to my graphic, we are squarely and firmly on the proper side of that line. We are not encroaching on the exclusive powers of the seat court. And what we are seeking in Pakistan could not be brought before the English court, because recognition and enforcement is not setting aside. It's properly before the Pakistan court, and therefore there's no basis for an anti-suit injunction. Of course, we may be completely wrong in our New York Convention application. There may be any number of reasons of form and substance that the Pakistan court considers are against us. But that is for the Pakistan court, not for the English court, and it must be tested by Pakistan law, not English law. Now that leaves what we have called the merits issues. And those are the issues that motivated the Court of Appeal, where it applied English law and asked the question, can you seek recognition and enforcement of points that are common ground? Can you ask for a preemptive application, recognition and enforcement, non-recognition and non-enforcement? Can you, in the circumstances of this case, ask for partial recognition and enforcement? Is this severable? Is paragraph 377 severable from the rest? Now, we've addressed those on the merits in my written case. My submission to you, the primary submission, is you should not be looking at those issues because they're all for Pakistan under Article 3 of the New York Convention and the flexibility that every contracting state has under the double control system. So it's not for this court to rule on whether Pakistan should allow preemptive applications, whether Pakistan or how it decides on severability of awards or common ground issues.
So you're saying, in the event that we're against you and we decide that what the Lahore court can do is governed by what the seat court can do, then this is what the seat court can and can't do, and hence what the Lahore court can.
Well, if you're against me and follow the approach of the Court of Appeal, you would then, as an English court, through the prism of English law, make findings on how the New York Convention should be applied in Pakistan. And I've made submissions on that, but I'm not taking my time on it because in my respectful submission, that would be totally...
It's completely flawed.
Completely flawed. Completely flawed. In the same way as this court would not take kindly to the Pakistan court telling it. Sorry, let me make it more emotive. This court would not take kindly to the French court telling us.
But it's not telling the court what to do,
No,
it's telling
the parties. Correct, of course. But one knows that indirectly, that's the result, that's the impact of it. I have detailed submissions on these. I don't have time to make them anyway now on the merits, but maybe in reply I would come back if that becomes an important point. The last area that I've not covered is if you are against me and consider that we have breached the arbitration agreement by asking for what we're asking in Pakistan, then under the established approach on anti-suit injunctions, you would have to, there's a consideration as to whether there are strong reasons not to proceed in that way under the test. And we've set out a list of those reasons in my written case, which perhaps mercifully at this point for you, I don't have time to cover. But they are linked very much to issues of comity and the working in particular of a multilateral convention where every contracting state under that multilateral regime has agreed that there will be other contracting states that will have a role to play, to whom a particular jurisdiction has been allocated by the treaty. And because of that international law angle on it, we say this is not a case where England is the only proper venue, the proper court. This is a situation where you can't deny that Pakistan has a role. And because that's something that we contracted into as a UK joining the New York Convention, that's a strong reason not to issue an anti-suit injunction against another contracting state.
Well, some of these arguments feed back really into your first part of the case as to why the regime works like it is, and it's not for this court to impose its interpretation of the New York Convention on another court.
But if we did get drawn into this last point, and we'd have to address, wouldn't we, the evaluative judgment that the Court of Appeal has itself made that it should grant
Yes.
injunctive relief.
Yes.
We would have to be able to say they've gone wrong in principle or have reached a perverse
Yes.
conclusion.
Yes.
But in effect, you're saying, well, do those things if you need to.
Yeah.
That's where you want your submission to rest if you get that.
Right. Would you give me one moment?
Certainly.
There's one further point I need to make, and then I'll sit down.
Yes.
With your permission, and that is, even if you are against me on everything, we have got one further point. I end on a point of optimism. There's one further point which we have in our written case, which I don't want the court to lose sight of, and that is. It is a.
You've lost sight of it, have you? Sorry.
Sorry?
You've lost sight of it?
No, I'm just trying to get the reference. But the point is that the existing order that the Court of Appeal has made, page 127 of the bundle. Yeah. So if you look at the order of the court made, sorry, this has become a jumble. If you go to 127 of the bundle and look at the order.
Sorry, just before we get there,
yeah.
You said there's another point made in your case. Can you just give us the paragraph number in your written case?
Yes. Paragraph 74.
74.
Yeah, paragraph 74.
Thank you.
So 127 of the bundle, it's paragraph 3D of the order that the Court of Appeal has made, which we say, on any view, regardless of everything else that I've said, is just too broad on its terms. The wording is, shall not commence or pursue any claim, suit, or other form of legal or arbitral proceedings against SHPL arising out of or in connection with the final award, other than by application to His Majesty's High Court of Justice. That would prevent my client from applying, plain and simple, for recognition and enforcement of the entire award, without saying anything else.
Which could not, you say, be contrary to the agreement.
Can't be right. And of course, there are good reasons why, even if, which we deny, but even if you were to characterize us as having lost on everything in the arbitration, we still have an interest in recognition and enforcement if we want us for res judicata purposes. Stop this being relitigated. So it's just too broad on its terms.
Yes.
My lady, my lords, unless I can give any further assistance, those are my submissions.
No, thank you very much, Mr. Landau. So we'll pause there. The court will now adjourn. We'll resume at 10:30 tomorrow morning. Thank you.